And the purpose of this morning's meeting is to continue our series of engagements on reform of the family law system. From the Childcare Law Reporting Project, we have Dr. Carol Coulter, the Director, and Ms. Maria Corbett, Researcher. You're both very, very welcome. From ARC Mediation, we are joined by Dr. Rushin O'Shea, the Director. You're very welcome also, Rushin. From the Bar Council, we are joined by Mr. Sean O'Hulican, Senior Counsel, and Dr. Sarah Fennell, BL, and Ms. Rachel Baldwin, BL. You're all very welcome also. And from Troar, we are joined by Dr. Ruth Barrington, Chairperson, Mr. Damien Pilo, Chief Executive Officer, and Ms. Mary Roach, Policy Officer. And you're all very welcome here this morning. Before we invite your spokespeople to make the opening statements, I am obliged to draw your attention as witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you were directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person, persons or entity by name, or in such a way as to make him, her or it identifiable. And members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. So, that all said, I'd like to now invite, in the order in which I've introduced you all, if that's in order, and I'd like to invite Dr. Coulter, I think, to make the first opening statement. Thank you.
Okay, well, thank you very much, Chairman, and thanks to the committee for the opportunity to address everybody here today. My experience of the family courts is twofold, because I ran a project for the court service between 2007 and 2008, reporting on essentially private family law. And for the past 6 years, I have been running the Childcare Law Reporting Project, which is public family law. And I do think it important that we make this distinction because there is a big difference in rights and in what is at stake between private and public family law, and particularly in the balance of power between the participants. In public family law, the state, through the Child and Family Agency, seeks orders which will take a child away from his family into care for a period that can last the whole of a child's childhood. And obviously, that's a very important power. It's a very awesome power that the courts have in that regard. So I am going to mainly focus on how public family law is dealt with in our courts today. The district court is the court that has jurisdiction to make care orders and supervision orders and related orders relating to children. So to start with looking a bit at the structure of the courts, I have had an opportunity to look at what some previous speakers have said to your committee, and I have to say I fully endorse particularly what Dr. Conor O'Mahony of UCC and the Law Society have said in relation to court structure and the urgent need to establish a family court. Next Monday we will be publishing a report on childcare hearings in the district court based on attending 35 district courts around the country in all of the districts. And we found overcrowding, lack of privacy, over-lengthy lists, overworked judges in most of the courts attended. In some of these courts, childcare cases were on a mixed list with criminal, civil, private family law and childcare cases. In most, the majority of childcare cases featured in a family law list, a general family law list. But these could be very, very long, up to 100 or so cases on a single day. People can then be waiting all day for their cases to be heard. The establishment of a family court division of the existing courts, with specialist judges trained in family law and allocated to these courts for a period of 2 to 4 years, with appropriate support facilities to allow for proper management of the cases would address many of the problems in family law. I would suggest 12 to 15 dedicated regional centres where there could be easy access for wheelchairs and buggies, adequate consultation rooms, a comfortable waiting area and a separate room for vulnerable witnesses and children. Basic facilities like drinking water fonts and a vending machine. No, that is not beyond our capacity to produce for the courts. No constitutional amendment is necessary to do this. Some improvements could be carried out to the existing system, and we made certain recommendations in a report published in 2018, but in my view they would essentially be sticking plaster. I think it is essential to have a new structure of the courts to ensure that they can deal adequately with family law. In relation to alternative dispute resolution, of course, it is desirable to keep family disputes out of court as far as possible, and alternative dispute resolution offers a useful alternative. Again, I think it is important here to make a distinction between private family law, between two individuals, and public family law. Public family law is not as suitable a vehicle for alternative dispute resolution as private family law, because you have the state on one side and a family which can be a very vulnerable family. Many of the people who come before the childcare case, they have a lot of problems. They are almost invariably poor. They sometimes suffer from disabilities, be they cognitive disabilities or mental health problems, and really that is not an evenly balanced situation when they're up against the state. It is very important that their procedural rights are protected, and that is done by our courts, which guarantee their procedural rights, including the right to legal representation. Usually the district court insists that there is legal representation, which is normally provided by the Legal Aid Board to families who are facing childcare proceedings, and most of the judges won't actually hear a case unless people at least have the opportunity to obtain legal representation. However, there are areas in child protection where alternative dispute resolution can be appropriate, particularly, say, in relation to disputes about access, when the children are in care, decisions about the education of the children, going on holidays, psychological and medical assessments of the child. People should not have to go back to court to get those kind of issues dealt with. They would be much more appropriate and suitable for that to take place in a less stressed environment. In terms of the conduct of family law proceedings, most of the proceedings are quite formal in the district court because they are conducted often on lists with all other cases, as I've just pointed out. So you have the usual format followed, with the applicant and their lawyers on one side facing the judge, the respondent's lawyers on another, the witnesses and the parents then sitting behind them, and that can be intimidating and I think very often confusing for some of the litigants. A specialist family court with dedicated childcare days should allow scope for a greater degree of informality, with parents, lawyers, witnesses sitting around a table with the judge attempting to resolve the issues. And that format does exist in the Children's Criminal Court, which deals with children who are accused of crime. And it would be a more family-friendly kind of environment. In relation to the voice of the child, children do not appear generally in the family courts, so mechanisms need to be found whereby their voices are heard. Again, some of your previous speakers have drawn attention to the limitations of the existing provisions for hearing the voice of the child, and we would endorse them. I'd also like to draw attention to a provision of the 1991 Childcare Act, which is the one governing child protection proceedings, and that allows a solicitor to be appointed by the court to represent the child in the proceedings. It's very rarely used. Usually, a guardian ad litem is the person who represents the voice of the child. However, in other jurisdictions, in Scotland, for example, also in Germany, lawyers are appointed to represent children from a very young age, as young as 2 years old in Germany. While I'm not saying that we have lawyers necessarily with the skills to do that in this country at this stage, nonetheless, I think that having a lawyer instructed to represent the voice of the child who are appropriately trained to receive such instruction should be part of a suite of measures to represent the voice of the child, and not putting everything on the basis of children having a guardian ad litem, which at the moment is being provided for and about to be provided for in new legislation. Just in relation to the in-camera rule, we have in this country two parallel regimes for reporting on family law proceedings, following legislation introduced first by then Minister for Justice Michael McDowell, and then a new law was introduced by Alan Shatter in 2013. The first provides for a variety of nominated bodies to attend family law proceedings and report. And provided people are appropriately nominated, it is not restrictive as to what reporting can take place, provided, of course, that the anonymity of all of the parties is protected. Then, in 2013, the law was changed to permit members of the media to attend and report on family law proceedings. But this contains a number of restrictions as to what can be reported. And the restrictions are listed in such a way that, in my opinion, it makes it actually very difficult for the media to report, because the penalties for breaching some of those provisions are very severe, up to €50,000 fine and 3 years in jail, or both. In addition, very few media organisations have got, in fact none that I am aware of, have the resources now to comprehensively report on family law. So there actually has been relatively little reporting by the media of family law, despite the introduction of that legislation in 2013. Then another possibility for getting further information about family law is, of course, having published judgments from the judiciary. The majority of family law is actually heard in the district court. Given the heavy workload of the judiciary, it's very difficult to see how they could provide written judgments in most family law cases. And there are no resources within the court service to provide for the redaction of judgments, which would have to happen in order to remove all possibly identifying information. There is a limited number of written judgments on childcare from the district court on the court service website, but I am aware that there's a far larger number available, but they cannot be published as yet because they haven't been redacted and the resources aren't there for the redaction. In my opinion, the only way to ensure balanced and systematic reporting of all family law proceedings is by way of a dedicated reporting body that can attend a representative sample of cases, staying with complex cases through repeated adjournments and publishing the exchanges between the parties' lawyers, judges and witnesses, as well as the court's conclusions. Such a body can and should apply a protocol to ensure the protection of the anonymity of the parties and filter out any identifying information before it reaches the public domain. We have a protocol which is published on our website, which specifies the kind of information that should never be published in order to ensure that there is no identification. Briefly, in relation to the rights of fathers, which I think arises mainly in relation to private family law proceedings, in public family law proceedings, fathers can and sometimes are named as respondents, but data collected by the Childcare Law Reporting Project has shown the majority of child protection cases involve only one parent, usually the mother parenting alone, with limited or no involvement of the father. However, where the father is a respondent, some judges have made rulings requiring the Child and Family Agency to prove that both the father and the mother are unable to parent a child safely before making a care order, and have directed the CFA to support a father in caring for the child where he is the legal guardian. And of course there are cases, we have seen cases, where the father is not the legal guardian and the court is then not able to make such an order. In other cases, however, the proceedings have tended to focus on the mother with little involvement from the father. And the issue of legal representation arises here because some fathers may not be able to avail of legal representation if they are above the means threshold, which is very, very limited. And I want to speak for a moment about that, because in my 2008 report for the Court Service, where I looked at private family law proceedings, I saw there was a specific inequity towards certain fathers due to the operation of the civil legal aid scheme. It is strictly means tested, and a situation often arose where a working father earning a modest wage was above the means threshold for legal aid, while his wife, if she was a mother, would typically not be working or working part-time, and she could fall under the means threshold. Therefore, if the relationship broke down, she would be eligible for legal aid, he would not. That gives rise to an inequality of arms in any kind of legal proceedings and is clearly unfair. A solution to this would be to remove or significantly increase the means threshold, while asking for a means-related contribution from litigants, so that a person on an average income could avail of the civil legal aid scheme and contribute according to their means. My colleague, Maria Corbett, and I will be happy to answer any questions the committee might have. There are 3 reports which I've left with the Clerk of the Dáil which go in more detail to some of the points that I've already made. And in particular, Maria can address specific issues relating to the impact of Brexit on family law proceedings, which is something we are quite concerned about. I know it's not on your agenda right now, but I think it's something we would very much like to draw the attention of the committee to. Thank you very much.
Thank you, Dr. Coulter. And now, on behalf of Art Mediation, Dr. Russian O'Shea.
Good morning, committee. Somehow this conversation always starts at the wrong end of the pipeline in the courtroom, and that is the wrong end of the pipeline. If I'm injured in a car crash, I'm brought straight to the emergency department. We need family ED, fast, effective supports. If the new norm was to first step into a wraparound, multidisciplinary, early intervention ED with mediation at its core, and with the ability to go straight to court in certain circumstances, we would solve the main problems of congestion, delay, significant cost, and the destructive escalation of conflict over time. So how do we do this? I first explored much of my detailed submission that I gave to the clerk in my 2014 PhD, which was a 3-year empirical study of 1,200 cases in the Circuit Court all over Ireland, which was funded by the Irish Research Council. We do not need to reinvent the wheel. We need to grab and adapt the most effective solutions from other jurisdictions and adapt them for the Irish landscape. In the District Court, I have found that family law litigants are experiencing 2 very different worlds. In the provincial courts, there are still impossibly long lists. However, litigants in Dolphin House, by contrast, benefit from a brilliant, innovative system implemented by Owen Manning, now operated by Eamon Doherty, where almost 95% of the litigants are now self-representing. Judges who have a huge commitment to the area have developed a quasi-mediation inquisitorial approach which reduces conflict in the courtroom. Judge Gerard Furlong is the lead innovator in this area, and he shows an extraordinary empathy, understanding and patience while implementing the law fairly. Right now, we should start to work with what we have. People cannot wait for shiny new buildings. We can't wait for reform of a system that is not fit for the users of that system. So where do we start? And I'm all about the users and I'm about solutions. So we start with families who are experiencing financial hardship. And the state should offer 2 access points for fast intervention. Path A, leverage existing state resources in the community at local level and start diverting people away from the courtroom. Our family mediation project, I'm involved in a research project with WIT, is available across the south of Dublin City in 4 family resource centres: Quarryvale, Killinarden, St Kevin's in Kilnamana and Ballyboden. Mediation is provided by a team of volunteer mediators from the not-for-profit Dublin Community Mediation. Appointments are available in 10 days. Means tested. There's a flat hourly rate of €25 that can be actually waived in financial hardship cases. It is child-inclusive mediation. Cases are co-mediated and by gender. It is court-linked. Issues that can be mediated are guardianship, custody, access and maintenance. The mediator assists the parents and children to access the wide range of supports available in the FRCs, including counselling, play therapy, parenting courses, support groups, referrals for mental health or addiction issues, which crop up in many of the cases we're dealing with, and can signpost additional resources such as MABS, FLAC and citizens' information. Path B. The State Family Mediation Service could then be freed up to focus on separation and divorce. Again, there needs to be a form of means testing. It's currently free, it's not working, the lists are too long, so that these state resources are targeted again for the users that need it most. A less complicated means testing approach could be used, and our research project has developed that, and we actually gave it to the AALS Family Mediation Project at Denver University, and they're running that at the moment. This two-level offering by the state for those who need it most, at local level and through the Legal Aid Board, would slash waiting times and get appropriate help to families at the earliest possible point. So if we're beginning at the beginning of the pipeline, we should have mandatory mediation information sessions, which is provided for in the Act, and mandatory intake sessions, which would help people to understand the process. And research in California shows that once people have attended the first mediation session, they tend to go on, 80%. The regulation of mediation must remain a priority. I'm in a working group convened by the Legal Aid Board to work towards forming a mediation council, and once that council gets about its work as set out in the Act, the uptake of mediation will then increase as potential users know what it is, understand the benefits and become confident of the training standards and competency of mediators. The two main reasons that I have observed for those choosing litigation as a first option is that A, people believe that or are being told that they will get a better outcome in a courtroom, and B, they believe that they will get their day in court and that a judge will tell the other person that they are wrong. People need to understand that neither is likely to be true. The overwhelming majority of cases that litigate actually settle out in the corridors of courtrooms. So in effect, people are actually coming to a settlement agreement. In terms of what can the government do in another area, VAT. The bulk of our private family mediation work we charge out at the rate of €123 per hour, and €23 of that is VAT. One immediate step that the government could do to support families in distress is to reduce the state tax element of fees. Those who need the services of a family mediator, and I would also say a family law solicitor, are individuals rather than businesses and therefore cannot reclaim VAT, which at the current rate of 23% is almost a quarter on top of the fees charged. Nuala Jackson, Senior Counsel, is actually here today. She sets out in our more detailed report that our framework for resolution of disputes must take the following into account. We must have satisfactory resolution for those who are in dispute. We must have it in a timely manner. We must have it with the least acrimony possible, and it must be affordable to those who are in dispute. So if we get to the end of the pipeline, what can we do about the courtroom itself? So first of all, we need specialist, volunteer family law judges with a genuine interest in this area of law, who are not rostered in or forced to take the cases, but actually opt in. We could use the 80-20 Canadian approach, where they do 80% of the time family law cases and 20% they do locum work or other material, because you go crazy if you do 100%, the judges tell me. And we should also ensure that specialist family law judges have an aptitude and personality suitable for family law. Not every judge that I have seen in the courtroom is a suitable person to be hearing family law cases. We need to change the jurisdictions of the courts. As our system currently discriminates against married people, they are forced to make any application relating to separation or divorce at circuit court level, which is generally a much more costly exercise with greater time delays. I propose that all private family law matters relating to children and maintenance are heard in the district court, and the circuit court deals with everything else in relation to separation and divorce. This would get this help to children fast that they need in terms of access and parenting. We need regional hubs with as many days as are needed, so that we can move to a case-managed system like they have in Oshawa Family Courts, Toronto, where specific appointment times are set for a case to be heard, and there is no gathering of multiple cases at a courthouse at the start of the day for call over. When I sat and observed the court cases in Oshawa, I was shocked that there was nobody in the building. I thought I was on the wrong day, the wrong building, and I realised, no, there's an appointment at 10, there's an appointment at 12, there's an appointment at 2. Users need predictability. The unfettered discretion of judges results in a considerable variation of approach and outcome, even with the same judge on different days. It is difficult to identify any pattern, with outcomes depending on the personal views and disposition of a judge. We need formulas that quantify maintenance and guidelines for all other matters. These actually exist in other countries, and if the committee want me to, I am happy to go and ask permission from Canada, New Zealand and Australia for us to use those here. They've already indicated we can have them. I'll go and ask for them. We need to encourage litigants to try mediation, and the state can further support that by opening up the courthouse facilities, which are empty on many days of the week, and use those for mediation sessions where a case is already underway and has been adjourned to allow time for mediation. Children. The most important and appropriate person in this whole thing is the child or children. And the most appropriate way to hear the views of a child in relation to access, custody and guardianship, private law cases, is in child-inclusive mediation with appropriately trained mediators. A judge then who is subsequently asked to rule or enforce any agreement resulting from mediation can then be satisfied that the views of the child have been heard. The court needs a panel of child view experts immediately available who can produce a report for the court within a reasonable time frame. If we operate a regional hub approach, then rather than this capped fee of $250 or $350, it may be more cost effective for the state, and I'm all about saving money for the state, is to have child view experts on salary. We should have parenting guidelines for judges based on international research so that a child's right to have both parents in their lives is effectively prioritised. In terms of parents, we need to ensure parity of treatment for both parents in our courts. Non-resident parents are overwhelmingly fathers in Ireland, and their role as parents is generally not supported by the current approach of the courts. Fathers are secondary or second-class parents as far as our court system is concerned. Where access orders are unilaterally breached, enforcement must follow, and it does not currently. And sanctions are open to the court under the 2015 Act, and these should be consistently applied. I'm in the district court since 2017, and not once have I seen it applied. I would like to thank the committee for the opportunity to make this submission, and my colleagues for their thoughts. Dr Sinead Keneally, Shane Dempsey, Nuala Jackson and Murray Dennehy. We, and three of them are here today, are ready, willing and able to do what we can for this committee to help. We will meet any member of the committee any time, day or night right now, because this is too urgent, and we will provide any assistance we can. We await your call. Thank you.
Thank you, Roisin Caoimhghín. And I'd now like to invite Sean O'Hulican on behalf of the Bar Council. Please, Sean.
Thank you for inviting the Bar of Ireland to this meeting of the Joint Committee to address reform of the family law system. My colleagues, Dr Sarah Fennell, BL, and Rachel Baldwin, BL, are in attendance with me today, and we'll be happy to answer any questions that the committee may have during the course of this meeting. Between us, I think we have over 50 years' experience in family law, and each of us have particular areas of expertise, and that's why the three of us came. It's a vast area. No one person covers the entire gamut of current family law practice. Our submission, which the committee has, sets out our preliminary responses to the issues identified by the committee which it wishes to address in the context of family law reform. I don't intend reading out that submission in full, but I would simply draw the committee's attention to some key points within it and then take questions. Firstly, the Bar Council is very strongly of the view that the expedient and efficient resolution of family law proceedings arising from a relationship and marital breakdown is in the interests of children and the parties to the proceedings. There are delays, and the delays currently experienced in family law proceedings do increase difficulties and complications which arise in the context of relationship breakdown, marital or non-marital. As you all know, family law proceedings are conducted as part of the existing court structure in Ireland. The present system allows the district and the circuit court deal with the vast majority of private family law litigation, and indeed, as Dr Coulter has said, childcare matters. You will see from our submission the statistics we have set out from a court service report for 2017, and you will see the vast bulk of cases in the system are district court cases of very serious import to the parties involved. The High Court is available to deal with more complex or urgent matters, or where it is simply thought appropriate that the High Court hear the case for particular issues of law, for example, might arise. In our experience, this division works quite well and reflects the ability of different courts to administer justice within their spheres. However, I think, as has been identified already, in Dublin there are dedicated family law courts. And while there are delays still in Dublin, they are not the chronic delays that can be experienced in other parts of the country. Outside of Dublin, the number of days allocated to family law sittings can be quite limited, which can result in system clogging and long gaps between the institution of proceedings and their determination, or broken hearings where you do a day here and a day several weeks or months hence. Not satisfactory for anyone, not even satisfactory for the court. As has been previously said, regularly on circuit and district, family law proceedings can be listed alongside the general list of criminal and civil matters, which is far from satisfactory. It is likely that family law cases will be dealt with more efficiently if a specialist division of family law courts and judges were created. In our view, this would ensure that the same judges would deal with the family law list on an ongoing basis, which we believe would not only ensure greater efficiencies, but also greater consistency. It is not envisaged, in our view, that specialist judges will be confined to family law, but will be assigned to that from the pool of general judges. I think historically there's nothing to indicate that because a particular practitioner practiced in a different area, that he or she could not adapt to being a judge in a different area. Training, of course, I think in the contemporary world is the key. As I've said, such a family law judge exists pretty much de facto in Dublin and can operate within existing structures without the need for a referendum, perhaps not even for legislation. There may, in some circumstances, depending on how reform goes, be a need for legislation, but I don't see the need for a referendum. And what we're suggesting is that the existing system can be made operate. But any division is meaningless unless it is adequately resourced. I think, as with all public services, it comes back to the resourcing. There is a lack of adequate facilities generally for the conduct of family law proceedings. In the absence of a purpose-built family law complex in Dublin, applications are currently heard and determined in various locations which are generally unfit for use. Current locations include childcare cases being dealt with in the district court sitting at the Bridewell. You may all be familiar with it. It's behind the forecourts, beside the Bridewell Garda station. I think it's a 19th century building which was used until it was revamped for district court criminal cases. It has been revamped, but it is still very, very unsuitable for the highly emotive, contentious issues involved in public childcare cases. People are in very close proximity with very inadequate facilities where emotions run very high. In addition, most private family law cases in the district court are dealt with in Dauphin House, and it's been there several decades. It's an old hotel behind the Clarence Hotel at the Parliament Street end of Temple Bar. It was fine perhaps once upon a time, but with the growth in the volume of cases, it is chock-a-block. Now, my colleague Rachel Baldwin would have more knowledge of this, but even in my memory of it, it was never very suitable and is totally unsuitable at the moment, notwithstanding the best efforts of individuals in the court service to make it work. Then there is Phoenix House in Smithfield, where the Circuit Family Court sits. That was a major improvement when it came in, but once again, the volume grows, times have moved on, and while it's not bad, it's far from ideal. Outside of Dublin, as I've said, family law applications are heard in the existing district court and circuit court locations on appointed days, as are appeals, circuit court appeals from the circuit court to the High Court. But due to the fact that family law proceedings outside of Dublin are generally heard on specially fixed days, the applications take place in courtrooms which were constructed in a different era for different purposes, and they're not particularly suitable for family law litigation. They may be suitable for criminal cases involving juries, they may even be suitable for civil cases, but they belong to a different era. Even with the revamping programme that has taken place in my lifetime at the bar, where a lot of money has been spent on redesigning courthouses, they are still far from ideal, and there are never enough adequate consultation rooms or family-friendly spaces. In short, it's not feasible in these venues to have properly designed resorts for family law cases, because they do only represent a portion of the business conducted in that courtroom. Now, I accept that's a bit of a conundrum, because while I'm talking about a specialist building in Dublin, and Dublin is big, outside of Dublin a huge assessment is needed as to how you deal with this. Is it regional centres of excellence? Is it separate buildings, or do you hive off part of an existing building? It's a big job of work, but I think it has to be addressed, and some start has to be made on it. So what we're saying is that the inconsistent resources in court venues and the lack of adequate consultation rooms, for example, directly impacts on the manner in which family law proceedings are conducted. The failure to provide separate waiting areas, as I've said, or family-friendly spaces, can significantly increase stress, which would be avoidable, and anxiety, which would be avoidable, prior to participating with a family law application. It's even as simple as, how does the lawyer consult properly with a client in privacy over very sensitive issues, or sometimes maybe less sensitive emotionally, but personal financial issues. It is very difficult. These situations of extreme stress can result in volatility in the conduct of the litigation, and everyone needs to remain calm. It's probably the biggest criteria that's needed to run these cases. So Our view is that in Dublin, certainly, the construction of the dedicated family law building at Hammond Lane, I think the committee is aware of it. It's behind the forecourts on Church Street, and there is a site there which was to have built on it a purpose-built family law complex, which would accommodate all the existing family law building courts in Dublin, and would also accommodate the Children's Criminal Court. It was a superb idea which the family lawyers, the Law Society, the Bar Council, the Family Lawyers Association threw whatever weight we had behind it. But unfortunately it seems to be stuck at the moment and is going nowhere. But if it was built, and I think it needs to be built, it would go a long way towards addressing deficiencies in the current family law system, and certainly in the Greater Dublin area. In addition to that, we are acutely conscious that in modern times, a properly functioning civil legal aid system is essential in providing access to justice. As you can see from the statistics, and as I've said already, the vast bulk of cases are district court cases. Huge numbers of people are going to be on legal aid. Whatever about the rows about the means test and what level it should be set at, and whatever about the good work that's done by individual solicitors within the Legal Aid Board and practitioners engaged by it, the system creaks along rather than works. And again, it's back to resources, and it in itself causes delay in the court process, where one party is on legal aid and another isn't, and there are delays because they're waiting to get their interview with the solicitor, they're waiting to get their legal aid certificate, and that has consequences for the entire running of the court system. It might only be another 5 or 10 minutes in each list, but if you multiply that by several cases, you can lose half an hour or an hour of a day very easily, and it can result in applications being brought by the other side, who may be privately funded, wanting to move it on, and the judge is trying to be sympathetic to the person getting legal aid, and you get costs built up as a result of that. So you do need a viable, functioning legal aid system. Finally, and as I say, I'm happy to take any questions, the areas touched upon throughout our submission simply demonstrate, in an initial view, how the administrative organisation of the court structure and improvement in court facilities can have a positive impact on how we manage family law and how we can expedite cases and hopefully reduce the cost of this to individuals over time. Thank you.
Thank you very much, Sean. Thank you. And our final opening statement is from Troer. And am I right, Dr. Barrington, are you taking the lead? Thank you very
Chairman,
much.
if I may, I share my time with Damien Pilo, our Chief Executive Officer. Thank you very much indeed, Chairman, members of the committee, for the opportunity to present Troer's view of the reforms that are needed in our family law courts. Troer has been in the business of providing specialist information service to unmarried parents and their children for over 40 years. So the issues that we will be bringing to your attention have been raised by the many callers, both on our phone line and to our offices over the years. Our aim is to achieve a system where unmarried families are recognised and treated with much greater respect than they are at the moment. I don't have to remind the committee that the recent figures show that more than 30% of children are born now to families who are unmarried, which means about 25,000 children a year. So this is a growing population of people whose rights are still very vague. We have a particular issue in relation to the rights of unmarried fathers in relation to guardianship of their children. We believe that every child has the right to know, as set out in the UN Convention on the Rights of the Child, every child has the right to know who its parents are, both father and mother. And secondly, the right also to enjoy the company of both parents. And as other speakers have said, if one starts from that position, I think you have to take a very different view of the interventions that are currently available for unmarried parents and their children. So I'd now like to hand over to Damien Pilo, our CEO, who will elaborate in more detail on some of these points. Thank you.
Thank you, Ruth, and good morning. Clare acknowledges that there has been far-reaching changes in family law over the past 5 years. However, despite these changes, significant deficiencies exist in terms of how the system continues to operate. And we deal with the consequence of this on a daily basis through our National Information Service. And two issues emerge in terms of the operation of the family court that we would like to highlight. One is the lack of information in the public domain, and the second concerns access to legal advice and representation and the question of economic inequality. 25 years ago, the Law Reform Commission report on the family law system noted that the structures for the mediation and resolution of family conflict were grossly inadequate. Fast forward to today, and the Family Mediation Service remains under-resourced, with people waiting from 12 to 26 weeks to get an appointment. Not enough has been done to ensure alternative dispute resolution is properly resourced and available for parents pre and post court. The failure to properly resource dispute resolution means that Ireland lags far behind other countries in terms of establishing and sustaining shared parenting. And as Ruth has said, Clare believes that all children have a right to know, be loved and cared for by both parents where possible. And shared parenting gives children the possibility of a nurturing relationship with both parents and their extended families, and works well if it is child-focused rather than adult-focused. In the Republic of Ireland, conflict between unmarried parents is often exacerbated by the fact that unmarried fathers do not have automatic guardianship rights. Even if his name is on the child's birth certificate, an unmarried father does not have rights in respect of his child. And this creates inequality in terms of parental rights and responsibilities, which often result in parents going to court. The adversarial route clogs up the courts and leads to tensions and conflicts between the parents. Clare is calling that automatic guardianship rights be extended to unmarried fathers whose names are registered on the child's birth certificate. And this practice has been in place in Northern Ireland since 2002. It would also mean that we have a national register for guardianship, and when we think of our children, and we talk about the future and children being our greatest asset, we don't have a current system where we know who the guardians of children are. And I'm going to say a little bit about the voice of the child. In 2019, people on low income remain at a disadvantage when it comes to the family law system. For example, those who qualify for legal aid must make a minimum contribution of €130, which is a substantial amount of money if you are dependent on welfare or are a low-paid worker. This means that those who are less well off often end up representing themselves in the family law hearings. This delays the process, places more pressure on an already struggling court system and increases tensions between parties. Inequality between those who have the financial means to hire legal representation and those who do not is replicated again when it comes to the voice of the child. Article 42, 4.2 of our Constitution enshrine the right of children to have their views heard in guardianship, adoption, custody and access proceedings. Under the Children and Family Relations Act in 2015, the Court has provision to appoint an expert to determine the views of a child or receive a report on any issues affecting that child. A fundamental flaw in this provision is that parents, regardless of their financial means, must pay for that report. People entitled to legal aid can get 50% of the expert report covered by the Legal Aid Board, but it's still a substantial cost. And Clare is concerned that many parents with low income are not able to afford this, with the result that the constitutional right of the child to be heard is seriously compromised. Simply put, the lack of legal representation, the cost of the expert report and the socio-economic situation of parents has a huge impact in determining access in full to the family law system. I want to say a little bit more about the information deficit. And a recurring theme from our work is a lack of knowledge amongst the population about the family law system. Inequality in terms of parental rights and responsibilities, which often result in the parents going to court. I read that one already. there is confusion. There is confusion about the meaning of guardianship and the extent and limits of people's rights concerning access, custody and maintenance. More worryingly, TROR has identified a significant gap in the knowledge of family law amongst members of the Gardaí, the legal profession, social workers and the judiciary themselves, as we heard from other submissions today. This is compounded by a pronounced geographical variation in how the system operates, especially in relation to the haphazard use of a very important document called the Statement of Arrangement of a Child. We urge the committee to recommend that a circular be sent to all district court judges emphasising the importance of this form and insisting that it be used. It's a very specific form that allows the courts, the judge, to have the history of the situation of both parents. TROR urges the Minister to introduce a national public campaign on these issues. In a major review of the family law, an Australian government introduced such a campaign, which has proved to be very successful in informing the public about their rights. In our submission, we have listed 5 clear recommendations that TROR believes will improve the family law system, and they include the extension of guardianship rights to fathers whose names are registered on the child's birth certificate, ensure that the National Mediation Service is properly resourced and a system of alternative dispute resolution is introduced, and shared parenting supports are resourced, and that the Minister introduce a national public campaign on key issues such as access, custody, guardianship, birth registration and maintenance, while we also acknowledge that that terminology is outdated and needs also to change. Thank you for your attention, and we are happy to take any questions you may have and continue to work with this committee and the Department of Justice to improve the system.
Thank you, Damien, and thank you, Ruth, and to all who have presented. Because of earlier indications of other legislation, I know that some members are under pressure. I propose to take members in the following order: Deputy Clare Daly, Deputy Jim O'Callaghan, Deputy Donnacha O'Leary, Deputy Mick Wallace have all indicated. So I propose we already had an indication of... I'm not on the prayer. Oh, you're not? Oh, no, I thought the airline bill issue was coming up.
Yeah, no, I'm okay. No, I'm prepared to take my time.
It's okay. Well, Jim, would you like to lead off?
Okay, I've no difficulty. First of all, thanks very much, all of you, for coming in. And it's been very useful for us all as a committee to listen to you. Just to let you know what our process is here and what we're trying to do. It's obviously a big part of our work programme for the year, reform of the family law system. And at the end of this process, we've heard from you today, we've heard from other people previous weeks, and we've our last sittings, I think, next week. We'll produce a report and we'll come up with some recommendations based on the expertise we've listened to, and we'll deliver that report into the houses of the Oireachtas. The chairman will launch it, and hopefully it will have some impact in maybe changing what we think needs to be changed in the system based on the expertise you've given us. Could I just start by asking a couple of questions? And Carol, if I could start with you, and just want to commend you for the excellent work you do in reporting of family law cases. You mentioned that there should be a dedicated reporting body. Do I take it that the Child Care Law Reporting Project, is that sufficient, or do you think that there needs to be something more than that?
I'm limited body, and we initially came into existence for 5 years. Then the Department of Children sought to extend that in order to inform the review of the Child Care Act, which is happening. And after a competitive process, we were successful in obtaining that. But we are time limited. I do think it is a model, though, that works, and I recently had an opportunity to speak to the child lawyers in England, where they're struggling very much with finding a transparent system that works in England. And various attempts to amend the law have not actually led to adequate transparency within the English system. Because each individual court can set what can and can't be done. And you can have arguments completely separate from the child protection proceedings themselves as to what reporting can happen. So it actually lengthens the proceedings, it doesn't solve anything, and it leaves the courts and the individual media organisations to struggle with the issue of anonymity and protecting the families. If you had a national system which I would propose, and I mean, as I said, we're time limited, so I'm not speaking about ourselves, but which could be attached to the court service and ensure there was a national protocol to protect anonymity, avoid things like geographically identifying the courts, because that is one of the dangers which exists at the moment. If, for example, a local newspaper goes in, the very best efforts of the Clare champion reporting a case in Ennis is still not going to adequately protect the anonymity of a family. Whereas if you ensure that geographical details aren't given, as well as identifying details in relation to the family, you can then show how the process is working in individual cases. And that model, I think, works very well. It's one which actually, I think, is now evoking some international interest, and there is a researcher coming from the UK next week to look at how this model works in order to see if it could be transferred to other jurisdictions. So I do think it has managed to avoid identifying the families while providing information on what happens within the courts.
And who funds the childcare law? Oh, beg your pardon, sorry, Maria.
Add to that.
Just to clarify that, the Childcare Law Reporting Project is only permitted to look at childcare proceedings. So, so just the private family law.
What about the other cases, like cases involving divorce or issues where there isn't a child?
Exactly. It's only public family law, and that is funded by the Department of Children and Youth Affairs at the moment. Previously, it was a mixture of funding from the Department of Children and Youth Affairs and philanthropic funding when it was initially established, but it is now entirely government funded.
And do you think it would be beneficial if the reporting of family law cases extended beyond simply the childcare cases that you have reported on?
Well, the court service, there was a project, briefly a pilot project for the court service over 10 years ago, which the court service funded, but that was again time limited. It was a pilot project to see if it could be done, and there is a report on the court service website, and I've also made available a copy of it to the committee as to how that was conducted. It was essentially the same model. And again, it was possible to report on private family law without identifying the families by just ensuring that there was an anonymising protocol. So I do think that can work.
Roisin, can I just ask you about the presentation you gave? Obviously, everyone would agree we should try to resolve family disputes at an earliest possible stage. But I suppose two parts to it. First of all, sometimes in family law environments you can have allegations or actual domestic abuse. And obviously under the Mediation Act at present there's certain types of cases which are precluded from mediation because of that.
It's not the case. So I'm glad you mentioned
this.
This is something that I feel very strongly about. In the pilot project that we're doing in the south of the city, we are mediating domestic violence, and I'll tell you why. Because if you don't mediate domestic violence issues, you're saying that the victim, or the alleged victim, A, cannot choose to use mediation, and B, the rest of their life which continues, so access continues, maintenance continues, their lives continue even when there is domestic violence. So I took my lead from a judge in Canada called Geraldine Waldman, and she actually set up a trial court where she had, the first part of the case was hearing the criminal allegations, so the criminal allegation of domestic violence, and the second part of the case was to hear the other issues to do with that family. So in other words, the evidence was heard in relation to, did an assault take place, did the psychological violence, whatever that piece was, and then she took off the gown and then she did the second piece, which was, OK, we've got maintenance issues, there's parenting issues, because as a judge said, I was in court on Monday here watching cases in Dolphin House, and one of the judges said to me, said to the litigants, because I'm listening, I always think I'm getting spoken to, but she just said that there was a young parents. The father was 21, the mother was 19, and the mother was saying that the father shouldn't see the child because he was a criminal, right? Yeah. And so the judge said, well, the judge asked him questions, and basically when he was a young lad, he was in trouble, and he's in trouble now, and so the judge said, just because he has a criminal record or has criminal sanction does not mean he stops being a father, does not mean he stops seeing his child. And it's our job to figure out what are the circumstances that led to an allegation of domestic violence? The thing about the Act that I really want to be clear on, and I fought on this and I didn't get heard, so there we go. I was one of the relevant stakeholders in relation to the bill. And myself and my colleague, Dr. Sinead Keneally, because I wear two hats, I'm in private practice and I do research, we said that that piece, part 3, I think, section 3, excluding the application of the Act to mediation where domestic violence has taken place. That's what that does. It actually doesn't say that you cannot mediate where there's domestic violence. It says that the Act will not apply to mediation where So, and I had a conversation with the President of the District Court, Rosemary Horgan, in a meeting with 5 judges, and we spoke about this, and I gave my view, and they would appear to agree with me that we should, and in fact, the first findings that I'm going to release out of our research project will be on domestic violence, and we're going to release the findings in May. And what we're going to look at is what are the domestic violence allegations? How many of them? What is the evidence? What's the nature? Because in Canada they break it up into 12 different categories. We're kind of doing this umbrella domestic violence piece. Physical violence is fairly rare, and in fact I would worry that those who genuinely are suffering from domestic violence are not coming into our courts. And then we have all the permutations of the break up of a relationship and the arguing and the fighting, and that's coming in as domestic violence when that's something different. It can turn into, but initially it may not be that. So I think, and I was really shocked to find that almost 16% of the domestic violence cases are actually parents who are in their 50s and 60s coming in to actually have an order to put a son or daughter out of the house, particularly in Dublin because they're assaulting them. Drugs and alcohol are the two huge issues that are not dealt with by the courts.
Okay, so you think that mediation should be still available even if there are circumstances involving domestic violence or abuse?
The mediation world, like any profession, there's a big split in the mediation world on this. There are many mediators who say, oh, you never ever mediate where there's domestic violence. I completely disagree. And what you do is you use parallel mediation. You never put them in the same room at the same time, not in the same building at the same time, and you don't tell them who's gotten a point with you when. Sorry, I'm hitting the microphone. Obviously you can tell I'm passionate about this space. You manage it. Your job as a mediator is to manage the safety and manage the space and manage the power imbalances. And I've taken my lead from Canada in particular and New Zealand, where they're working this really successfully. Okay,
thanks very much. Sean, thanks very much for coming in, yourself and Sarah and Rachel as well. One of the things we discussed at the previous hearing was how the voice of the child can be heard in family law proceedings. And I'm just wondering, from your practical experience, all of you in fact, like how is there inconsistency between how a judge will hear the voice of a child? Is it done in affidavit? Is the child called to give evidence? Does the child go into the chambers with the judge? Or do you think it's an area where there needs to be specific guidelines?
Ms Baldwin on this, she'd have far more expertise in this area than I would.
Yes, there's a great degree of inconsistencies. It's case by case, it's judge by judge. And I think with the voice of the child, what hasn't been highlighted is when the regulations came in this year, and obviously there's issues to do with the fee applicable in relation to them, but there's 2 types of reports that the courts can order, and one is the voice of the child, and the other is a question affecting the welfare of the child. And all judges will make decisions in relation to access guardianship and custody where the welfare of the child is paramount. So I think it was highlighted by someone else that this is child-focused, it's the child's right to have access, if appropriate, to their parents rather than the parents' rights, because there can be so much conflict between parents, obviously, and the majority of judges, in my opinion and in my view and experience, have said, look, this is about the child's right, it's not necessarily about your right. So the problem with this Act, when it came in, there was no guidance, I would say, as to how this was going to be done, how it was going to be funded. As was pointed out, it's to be funded by the parties. The Legal Aid Board did step up to a certain degree and contribute where they had, where someone did have a legal aid cert, and they did contribute towards that. And obviously these regulations have come about, and I would say that the fee is completely just inappropriate or just not proper for the type of report. But the difficulty is, if you have a voice, just the voice of the child, that doesn't necessarily take into account everything, because you might have a case where the child has been exposed to conflict, be it domestic violence or just marital or non-marital breakdown and conflicts between parents, or you might have a case where the child actually hasn't been exposed and the parents have kept them away, and they might have a particular view either way, but that's not necessarily in their best interest to have access certain days and other days. And, a lot is said about, fathers' rights, and absolutely that goes without question. But it might not be in a child's best interest to have 3.5 days with either parent or both parent. They need a degree of, obviously, consistency, and usually if they have a base, be it because of school or their social activities or their friends or whatever, and then they can see the other parent. Obviously work is also an issue, obviously if both or either our parents work, and also a side issue which does come up, and especially in Dublin I find that it might be a case that the courts are more than willing to give overnight access, midweek access, weekend access. The parents are actually agreeable to that, but the parent who doesn't have the day-to-day primary care control of their child doesn't actually have the housing or the ability to provide overnight access. So that happens quite a lot, where there's no question, there's no issues actually between the parents, but unfortunately there's just not the accommodation to provide for them.
So if I beg your point.
Just following on from what Rachel said, I think also we just need to draw a distinction between public and private law cases in terms of the variety of mechanisms to hear the voice of the child, because what's commonly utilised in public law proceedings would be the guardian ad litem procedure, whereby that isn't activated in family law proceedings. It is on the statute book, but it never commenced, and that was confirmed a number of years ago in the High Court. So there are a variety of mechanisms to include, depending on the nature of the case, in terms of public or private law, a guardian or not. There's also Section 47 reports, as we would traditionally know them. They can sometimes now be referred to as Section 32 type reports, and sometimes they're used interchangeably. They are different sections within the Act. There's also provision to join children as parties to proceedings, or to have children have their own independent legal representatives. Those two mechanisms are used quite rarely, in fact. And the other mechanism would be that a judge would hear a child in chambers. That is dependent on the particular judge. There are judicial guidelines in place from the High Court to guide judges in that respect, but it will be left to the discretion of the individual judge whether that's appropriate or not. I can only speak from my own experience, which would be primarily in the Circuit or High Court, that it's the Section 47 type reports that are most commonly utilised, and that they're in private law cases, and in the public law cases it tends to be the guardian ad litem's, or in those cases where you have special care orders, where often teenage children might be detained. In those situations you might have judges speaking with the particular children. But we do have to be careful. That does in itself raise constitutional and procedural issues as well in terms of the balancing of rights. So we have to be somewhat careful in that regard.
Rachel and Sarah, Deputy.
Just in terms of what Ruth and Damien were saying, and I'm going to ask them a question about it in due course, they were saying that they think the system would benefit if there was automatic guardianship rights for fathers. What do you think would be the practical effect of that on the family law system that operates at present? I'm not asking whether you agree with it or disagree with it, but what would be the effect of it, do you think? Or is it easy to predict?
Probably not, in the sense that the 2015 Act only commenced in January 2016, where the new provision in terms of guardianship commenced. Obviously that was a significant development on what had existed previously under the 1964 Act, even in its amended guises over the years. So I think it's probably somewhat early at this stage to flag exactly what the position has been following the 2015 Act. In terms of the position of unmarried fathers. Okay.
Can I ask you, Ruth and Damien, like sometimes there's a perception that fathers don't get a fair crack at the whip, if I can use that expression, when it comes to the family law courts, and generally they're balanced in favour of the mother, particularly when it comes to, I suppose, custody and access. Do you think that's correct, or do you think that perception's unfair?
Well, certainly in relation to unmarried parents, that is correct, because in law, traditionally the unmarried father had no rights whatsoever. Now, the Child and Family Relationships Act has extended in a very limited way the guardianship rights of fathers who have lived for 3 months with the mother before the birth of the child, they can now apply to be the guardians of the child, but it's not registered anywhere. It's done by agreement. It's done by statutory declaration, which of course they get lost. They can be torn up. Somebody can claim it was never registered, because there is no register of guardianship for those who are not married. If you're married, the marriage register is the register of guardians. But if you're not married, there is no register of guardianship rights. And as I say, this, when children born to unmarried parents were a tiny proportion of all births, this maybe wasn't so significant. But now with a third of births being born to children being born to unmarried parents, it is a significant social problem, which I don't think has been recognised or addressed appropriately in the Child and Family Relationships Act. Damien, you may want to.
Well, it's also I think in relation to the perception that fathers themselves feel that they don't have, unmarried fathers particularly don't have equality of rights, and they often feel disenfranchised from the system. And one of the things, whether guardianship has a big impact on the family law system or not, it certainly should have a big impact on fathers' attitude to their responsibilities in relation to their children. In one way, by not providing guardianship rights, it lets fathers off the hook of that responsibility and denies them a right that they should have from birth. But so you think that
a reform you think should be introduced is that unmarried fathers should be given automatic guardianship rights?
Yes.
Okay.
As is the case in Northern Ireland.
When the names are on the birth certificate, I think though you have to see it as part of a kind of holistic approach to reform of the system. And if you look back at going right back to the 1990s, the Law Reform Commission reports, they talk about supporting families and how you support families. And of course it goes into, the court system doesn't operate in a vacuum. It's part of the broader society. And the issues that we deal with on a daily basis that put huge pressures on families. There's alcoholism, drug abuse, poverty, lack of housing. We have fathers coming in who are living in hubs, mothers then who say, oh, he told me to leave, I have to leave the house or whatever, but the children, and I have no rights. So I think the issue around fathers' rights, it's about a part of a broader suite of trying to reform the system and about how people think about it. In other jurisdictions, they don't use the terms, and the Law Reform Commission reports talk about this. They don't use terms like guardianship, custody, access. They're talking about parental responsibility, day-to-day care. They talk about contact in terms of access. So the terms we're using are considered to be parent-centred terms, instead of getting to terms that are child-centred, and supporting families as well, putting resources, so people have access to public housing, people have access to mental health services, and you're in a proper situation then, your family law system sits within that broader context.
Okay, thank you very much.
Mary. Sorry,
Thanks,
Deputy Rushin indicated she might like to add something.
Two quick points. One is that the default access orders of the courts, both district and circuit at the moment, for non-resident parents who in 97% of cases are fathers, is every second weekend and one night during the week. And when I was doing my circuit court research, I interviewed 15 of the judges and I asked them, where did these orders come from? And it took nearly 2 years for me to figure it out, and for these judges. What we figured out and learned was that these orders were actually coming from expert reports when there was a welfare issue raised in relation to a child. So the every second weekend and one night during the week was meant to be the least amount of time a non-resident parent would have with a child, not the norm. And what has happened is that all of our courts now order that as a norm. That is impacting on fathers, and that is a very serious issue. How do we resolve that? Parenting guidelines. It's really simple. Other countries are doing it. Parenting guidelines. There are parenting guidelines in Canada that say that children who are under the age of 5 or 6 shouldn't be more than 4 days away from the other parent, the non-resident parent. There shouldn't be these big blocks of time. And the second piece I just wanted to raise really quickly, mediation under the Mediation Act that came in last year, January of last year, is now court-linked. So in other words, if a case rocks up in court and hasn't tried mediation, under Section 16 of the Act, a party to the proceedings can ask the judge to ask both of them to consider mediation and go back to mediation and try it. And the thing is that parenting, in the project that we're doing, we've done 50 cases. It's now running, and we've only just launched it in Dublin, but of the 50 cases that we did, parenting time for the non-resident parent improved in all cases. And 80% of the fathers coming in the 50 cases didn't have any access at all. So I think we could address the imbalance in parental rights by good, competent mediation linked to our courts, because under Section 11 again of the Mediation Act, it is now for the parties themselves to determine if a mediated agreement is to be legally binding and capable of enforcement. So if they do a parenting agreement in mediation, somebody breaches it down the road, it can be brought into the district court really fast and enforced. And the judge has this really clear picture of a child's life, what time they get up, when they go to bed, when they go to see Mary, when they have their communion, when they go on holidays, when they do things at Christmas, every part of a child's life. And a mediator can sit down and do that carefully and slowly based on the parents and the child. A judge cannot. Of the 375 cases I've done in the district court, less than 10 minutes is the full hearing time per case.
Thank you, Chairman. I'm finished.
Okay,
My questions.
Deputy O'Callaghan, thank you. Deputy Clare Daly, followed by Deputy Donnacha O'Leary, please.
Thanks, Chair, and thanks to everybody for coming in, although it's absolutely, utterly depressing listening to everybody. It's just... It's incredible, and I think it's brilliant that you have come in, because it's such an important area, and our failure to deal with it as a society is so enormously damaging that there is an imperative on all of us to listen to the advice that we're being given, but also to act on that. And I suppose some of the saddest parts of it is that some of the issues have been well flagged and haven't been acted on for a whole period of time. So I suppose some of my thoughts on it are a little bit eclectic. I'll maybe throw out some stuff, but I wanted to start on some of the stuff around the voice of the child and that whole area, because if we did look at things like that in a real sense, I think things might be different. It would be a good starting point. And obviously the Act in 2015 gave directions on for an expert report to be done in relation to the welfare of the child. Now, I know the Bar Council talked about recently about some of the regulation in the child view experts being problematic, and that, not least, I think he said, on account of the maximum fee being set. So I just want to explore some of those things. I suppose the first thing on that is that, well, why are the regulations problematic? Particularly, what's the issue around the maximum fee chargeable? To me, it would seem sensible in a certain way. I mean, I've heard of people paying thousands upon thousands for Section 47 reports. Would it be better to cap them, or to maybe take Roisin's suggestion of a sort of a state-funded scheme? Would that not be better? I suppose the next thing are the difference between Section 47 reports under the 95 Act, I think, and then the Section 32 reports under the 2015 Act. Are they the same? How are they different? How come Section 32 reports can be done by psychiatrists, psychoanalysts and social care workers who've undergone specialist training, while Section 47 reports can be done by whoever the Health Board deem qualified? And this is a huge problem now, as far as I'm concerned. Is there a fee cap on the Section 32 reports? I think they have one, but the Section 47 ones don't, which is more commonly used. And the reason behind this is we've seen a lack of consistency. Some judges sit down with the children, ascertain their view in a very nice, all-encompassing way. Most judges don't. They probably think that's kind of hippie nonsense anyway. Why would you be bothered wasting your time, and they've too much work to do, or whatever? I'm not really sure. But do you think there's a limit in the Act? Because the Act that gave power, if you like, or constitutional, I suppose, gave an enactment to the constitutional provision to recognise the voice of the child, only talks about the views of the child where they are ascertainable, and that the court may. Do you think that the Act should be changed to shall? Like, should the voice be required? Because some judges don't do that. And in that context then, there is a huge issue with the Section 47 reports, because I've heard a lot of people saying it's not the voice of the child, it's the voice maybe of the psychoanalyst, for example, who takes a certain view. And, you know, it's hugely problematic that this is an unregulated profession. I've raised this issue with the Minister many times in the case of psychoanalysts. It'll be 2 years before the profession is fully analysed. So anybody can call themselves a psychoanalyst and could be authorised to have a Section 47 report. There's a gap in the law. If I don't like that report, there is nowhere I can go to overturn that. And is it your experience that the practice is that actually, even though the judges may take these, they've become the gospel for a lot of judges, against the backdrop where there's no mechanism that that report can be complained about or appealed, because it's an unregulated profession. Now, to me, that is an incredibly daunting and worrying situation. So I'd like to hear people's comments on that. How do we improve that situation as well, that the voice of the child can really be heard? Because as far as I'm concerned at the moment, that isn't being dealt with properly.
Okay, I'll take Carol first, and then Rushing and Sean, and we'll take everybody as they please then after that. Carol, please.
I'll be very brief, and again, in relation to public family law, where overwhelmingly it is the guardian ad litem who is meant to present the voice of the child. But guardians ad litem under the 1991 Act and the new Guardian ad litem Act doesn't no longer, well, it hasn't come into force yet. They have two jobs. One is to represent the views and the other represent the welfare of the child. And they may not necessarily be the same thing at all. So I think there is a great danger in that system, that what you get is a guardian ad litem representing what he or she thinks to be in the welfare of the child, and the views of the child getting lost. Of course, children may not always be the best judges of what their own long-term welfare may be, but nonetheless, their unfiltered and unadulterated views do need to get representation before the court. And I know that there are a lot of other issues in relation to the private family law, but I think that needs to be clarified. Having an opinion as to the welfare of the child is a different thing from presenting the views of the child, and it must be ensured that the views of the child, be it through their own legal representation or through an expert or through a guardian, is represented in an unfiltered way, so that people are sure of what those views might be.
Thank you, Carol. Rushing.
Yeah, I think, first of all, our constitutional piece isn't quite in keeping with the UN Convention. I mean, basically, children in this state under the UN Convention have a right for their views to be heard if they wish their views to be heard, not if we can ascertain them. It's not the capacity of the child, it's the child's desire for their views to be heard. And we've already had a little sanction note sent to Ireland to say that we're not compliant with that. The issue is in terms of how do you hear the voice of the child. I brought 10 Canadian judges here in 2010 to a conference that Liam McKechnie did the emceeing piece for, and 4 American judges and a couple of New Zealand judges. And the Canadian judges in particular were really shocked that the Irish judges were hearing the views of the child without appropriate training. In Canada, you have to, as a judge, have training every year, CPD. How do you hear? How do you know if estrangement is there? How do you know if there's parental alienation and coaching going on? If you don't have training. Now, the judges that I interviewed, they often said, but I was a parent. That's not the answer. Being a parent does not make you best placed to hear the views of a child and hear the complexity that can be around that. I think we have a difference in the private family law space, as Carol was saying there. In the private family law space, if you're legally aided, if there's a report, it's paid by legal aid. Am I right, Nuala? Yeah. To an extent, sorry. But if it's private, if you're not legally aided, what I've seen, and I will be publishing this later on, is that delays are being caused possibly strategically because people know that the cost of these reports are so heavy, or even when it's through legal aid, that the delays are so long. And what happens then, I saw it on Monday, I saw judges hearing cases where Months have gone by where a non-resident parent is not seeing the child, and the judge is saying, now we have estrangement because the child hasn't seen the father. Invariably it's the father's, unfortunately, for 6 months, 7 months, 8 months. And they're saying, so we can't go back to normal parenting, we'll have to start with estrangement. And our system has done that. It actually isn't even the parents themselves, it's our screwed up system. Pardon my French.
Russia, before bringing Sean in, just 2 things that I need to do. Number one, I want to extend a sincere welcome to all in the visitors' gallery, and I mean that sincerely. And we now know you're Nuala. And I have to say, and we don't write the protocols, but I'm afraid that'll be the last opportunity that Nuala will have had to contribute here today. And I just say to witnesses, it is only the witnesses. The visitors' gallery cannot be consulted. We'd change things, but
He actually loves protocol.
don't mind that. Don't mind that. Sean, you have the floor.
Thank you, Chairman. Deputy Daly, there are a lot of issues there, as you say. I will start with some of them on a sort of maybe a historical and overarching level, then hand over to my colleagues. As you say, the Section 47 report has its origin in the Family Law Act of 1995, and just interestingly, that section has never been commenced to operate in the district court. And how the district court operated was always on a bit of a needs and must basis over the years. I suppose a resourcing issue as well, and district judges would tend to find other ways around it through sections in the Family Law and the Child Care Acts until the HSE or the previous health boards complained that they were utilising their social workers too much. So it's always operated as a poor relation. But I think in fairness to the assessors in the Section 47 cases in the Circuit and the High Court, which by and large would be in the context of a judicial separation or divorce case, where all of these other issues relating to children would form part of the overarching case, the assessors would generally have been from regulated professions, child psychologists, child psychiatrists. Yes, there would be occasions when there would be others. And there would be a cohort of people whom the practitioners would know, whom the courts would know, who would in general be very well regarded and who would have provided very objective expert witness reports as opposed to hired gun reports. And so I think it would be unfair to castigate that cohort of people, child psychologists and child psychiatrists, who in the main did this. Yes, there was a cost to it and there was an inequality of arms and still is, because as Nuala's last intervention indicated, the Legal Aid Board wouldn't fund these at a proper commercial rate. So it meant that the person privately funding their case would be able to pay for the appropriate report. And the view, I think practitioners would find that the Legal Aid Board, notwithstanding the best efforts of those working within it, would be very reluctant to pay for a proper report, parsimonious. I should say the same would apply if the person in legal aid wanted, say, a specialist accounting report or other specialist evidence. It would be very hard for counsel acting on behalf of a client legally aided to get the evidence, and you'd always be on the back foot as against a privately funded person who could afford the accountant or the child psychiatrist. But in general terms, I think those reports worked well, and while the district court did its own thing, I think it was section 20 of the Child Care Act of 91 they used to rely on at one stage until they were, I think, told to back off. It worked reasonably well, but so I don't think you could say that that system doesn't work. It's a cost issue. In terms of appealing, any decision of any court is amenable to an appeal. So you could appeal a decision of a district judge on a report to the circuit court, or a circuit judge on a section 47 to the High Court. I appreciate that you're still dealing with the report, and I accept that it is difficult to overturn them. And the few occasions in my memory in which it occurred, it would be more undermining the research methodology used, or the methodology used by the assessor, rather than the actual findings. But again, it's a question of commerciality. Who's going to go to the cost of getting yet another child psychologist or child psychiatrist in to counter the evidence of the assessor? It becomes an expensive process. But it can be done. In terms of strategic delay, I hear what Dr. O'Shea says, and yes, that happens. But in reality, no matter what system we come up with, no matter what finds favour with the committee or the Oireachtas, there are always going to be outliers statistically. And in my experience, and I think probably in the experience of my colleagues, most people do not engage in strategic delay. They want to get the case done. They want their children looked after. They want to be able to move on with their lives. And in fairness to courts, that's what courts try to do. They try to get people to move on with their lives, rather than forever spent in looking back at yesteryear. That's a positive thing to do, and practitioners try to do that as well. So I think the numbers of people engaged in what you might call a strategic delay are minimal. They will exist, I think, no matter what system you have in place. And I think that goes back to, in our submission, a lot of things are interrelated. There's no sort of thing in our submission that you could fix one thing and leave other things go. That's why we say you must have judges with appropriate training. I think we're all agreed on that. And they should be in place for whether it be 1 year, 2 years, whether it's an 80-20, as Dr. O'Shea says, or full-time 1 to 2 years. Then you get the consistency in terms of all issues, be it how they evaluate strategic delay, how they evaluate reports and assessments, how they evaluate sanctions on people, whether they be cost sanctions or otherwise. But that's another complication in the family law arena, which is very different to the general rule of cost follows the event in general civil law. So it's not all bleak. There is a structure there, and it can work very well, but it does require consistency on the part of judges, also on the part of practitioners and the experts coming in, and a functioning civil legal aid scheme. But I just ask, I think my colleague might want to add a bit, Chairman.
Well, I think both were indicating.
Oh, sorry,
this last there. So I'll take Rachel and then Sarah, please.
Just briefly, and just what Sean says in relation to the consistency, I suppose if there is a judge who's dealing with it for a period of time, it is better, because the difficulty is sometimes you'll have a case that comes before the court, and depending on the court's view and the judge's view, what they will or won't do, there is circumstances where a court might adjourn the matter to allow a child to come in to convey their views and wishes. And when it comes about, then that particular judge on that particular day doesn't necessarily want to do that or put that child in that position. So it does depend on the lack of training and consistency in relation to that. Just to go back to the question about the Section 32 reports, as Dr. Coulter pointed out, the guardian ad litem in the childcare and the public law system looks at the views and also the welfare, and they might not correspond with each other. And that's the difficulty we have with the Section 32 reports, because there is essentially two reports. There is one with the views and wishes, and there's one in relation to the welfare. The regulations themselves just deal with the voice of the child themselves, and that doesn't take in the overall issue. And then your question just in relation to the fees, why might they not be proper? It depends obviously on the professional and how they conduct themselves, and that's a matter for themselves. But they might meet the child with mum, they might meet the child with dad, depending on their age. They might meet them by themselves, obviously brought by one parent. They could do play therapy type things. They could also just speak to them directly, depending on their age. So there's usually quite a few meetings, and then they actually have to write their report for the court. There is also provision that you said about questioning them or appealing them, and they cannot, if either or both sides aren't happy with the report or have certain questions, you can call them to give evidence in relation to that and cross-examine them. And like that, if there's something you're not happy with or wasn't said, you can ask what their view would be. If a parent moved closer, would you have a different opinion or that? So they can be questioned, and then as Sean said, you can appeal that in relation to it. Just one thing, just briefly in relation to the delays. While this Act obviously brings about the views of the child and taking the child into the case, so to speak, from their point of view, obviously that in itself will lead to delays, because on the first day, like you say, it might be a case of adjourning it for the child to come in or to order a report. So that in itself, necessary delays, but will cause delays. Majority of judges, unless there's an overarching question in relation to domestic violence or otherwise, a lot of the time they will order an interim order in relation to access or otherwise, and they that is. Sorry, I lost my train of thought, but that is the case. So it does lead to delays, but in fairness to the courts as well, they try and manage that. So it might be adjourned just for a week for mention, which means that you might say, OK, I have 3 names of these assessors, these are the fees, this is how long they can do it, and this is when they can start. And a judge will say, OK, I'll put it back in a couple of weeks' time or a month's time to see if that report has been done, and if so, we will set a hearing date. So they do micromanage. Again, this is from their own point of view and without necessarily having the training behind it, but I do think they are trying to do their best with what they have.
Okay, Rachel. And Sarah, just the last in this particular approach.
Just in response to Deputy Daly's question in respect of the workings of the Section 47 report system, just to indicate that on the ground in terms of court hearings, what would regularly happen is if either side challenged the findings within the report, the assessor would come to the court to give evidence, and the assessor can be examined and cross-examined by the legal teams or by the parties if they're not represented in the case, and that would be commonly done. And there certainly is case law which indicates that the Section 47 assessment is a tool in the overall process, so that certainly judges shouldn't in any way be bound by it, but it is a factor that they take into consideration. And the second point, very briefly, in endorsing the comments that have been made in respect of the need for specialist training for judges and in terms of assigning judges from a pool, I would also just indicate, just caution that we don't fall into the danger of looking at family law in a vacuum, as if it is separate from other spheres of law. Family law sometimes has a tendency to be viewed perhaps as a non-legal topic. It's very legal, it's complex, that's just inevitable in many cases. It involves elements of constitutional law, EU law, international law, jurisdictional disputes. So company law, pension law. So there are various elements to family law cases, and I think we just have to be careful that we don't try to separate it, as I say, as a distinct sphere separate from other legal spheres.
Thank you, Sarah. Deputy Daly. And maybe just in terms of, if you would like to direct maybe your questions specifically, whichever.
I don't want to dwell. I mean, I do a lot of those points around the Section 47 have to be seen in the overall context of the lack of training and all of the other points that might address that deficit more so. But I stick to my point that in the present scenario, it's an incredible, there's a power imbalance there with the person who does that report. That's just a fact in my experience. And a parent who doesn't agree with that report, where it's been done by a psychoanalyst, which is not a regulated profession, couldn't complain about maybe the conduct of that person in dealing with the assessment. They've nowhere to go, obviously, a psychiatrist and all the rest you have, but in the instances of that, even where some of those people are very well known by the courts, if I get a report done by that individual and then I have to go in and question that, I'm on the back foot, and I'm the neurotic mother or whatever that I've been portrayed on, and I don't agree with that, but I've nowhere to question that. So I think there is a power imbalance there, and I do think as well in terms of some of the issues, while I hear what you're saying about selective delays, and in my experience some people do actually, it's not that unusual. It may not be the majority of cases, but some people do try and drag it out and cause enormous hardship in that as well. But just maybe a couple of the other points, and again this is a bit eclectic because I don't want to repeat points that you're making, I just want to kind of tease things out for myself. So one of the things, Roisin, you had said about the access cases and breaches of access and no sanction at all being there for that. But I mean, obviously, you know, nobody would be in favour of sending somebody to prison. Fines don't really seem that appropriate either. Does anybody have an idea what sanction could you possibly have for something like that?
I suppose, okay, so yes to the first part of your point that the sanctions are, I'm currently not seeing sanctions in the district court in private family law cases. But under the 2015 Act, we do have sanctions that a judge can use. And I was asking why these sanctions aren't popping in the court. And it would seem to be that when I say the court, Dolphin House has got 95% self-representing. So the staff in Dolphin House help litigants fill out the paperwork, which is the brilliant innovation. That's really, really good. But they're dancing a fine line of not giving legal advice while they're helping them fill out the paperwork. So you find people are filling out paperwork and don't realise they should have filled out another form to say that they wanted to not just come in on a breach of access, but come in on I want such and such a sanction. So the sanctions that are currently there under Section 60 of 18A is compensatory time. So the parent who's been refused access, the judge may give that parent longer periods of time to offset the adverse effects of break in contact. So that's a sanction, but it's actually a good sanction because it actually is giving parenting time to the parent who lost out and extra time on top of it. And also the parent who had to come in to enforce their rights, father or mother, may be reimbursed for any expenses incurred in trying to enforce the rights. I haven't seen that coming up at all, and so because the judges are saying to me they're not sure how they might do that if it came in front of them. In other words, are they reimbursing for the lost day of pay to step away from the job for the day? Are they paying for the bus fare to get there, or the taxi, or the Lewis, or whatever? And then the judge can also ask one or both parents to engage in family counselling, individual counselling, mediation, or a parenting programme. Now, all of those sanctions are where one parent unreasonably denied access based on existing court orders. So it's there. And I actually went into the district court in 2017 because I thought I'd start seeing this. This is what I was looking for. It's my colleague Sinead Keneally and I doing the research. And we're in 2019, and I'm not seeing it once. Now, we're only 400 cases in, but in 400 cases, I'm not seeing one application. And it's like going into to get your tax disc or whatever, and you get the ticket out of the machine. Nobody's pulling the ticket. So a judge operates to the ticket that comes in. This is just very layman's language. But you fill out a form and it goes in front of the judge. The judge only can deal with the ticket in front of him or her. So if the person hasn't filled in a form to say, I want to actually, you judge, look at these sanctions, give me one of these. If that doesn't come into the room, the judge can't do it.
Well, I think that's useful, and they are good sanctions, as you say, actually, and that should be done. Yeah. Sorry.
To go in.
Yeah, a couple of points on it. Again, around the issue that we come across a lot is that when a court order is made, parents often think that's the letter of the law, that they can only do that. So if it's the 2 weekends, visitation rights on 2 weekends, or custody on 2 weekends, and once during the week, and anything outside of that they try, there's very little room to negotiate, especially if the parents are not getting on, and they don't put the child at the centre of that. And one of the big things that we found is the lack of information that's available to parents in terms of what actually can they do. So, as Roisin has said, around the possible sanctions that they can apply for. But the other one is this whole notion of shared parenting, which is a whole different philosophy and way of working, that you're putting the child at the centre of the it's not about the adults anymore, it's about the child, and how do we work collectively together. And what we found is that parents who go down the shared parenting route are much more able to negotiate when there are breaches, or when they have issues around access, and when they have problems that they can't make, or whatever the reasons are, and they're much more willing to be flexible around their arrangements with each other. So for us, we have carried out a piece of research last October that looked at the barriers, and the whole issue to shared parenting was this sense that people get stuck in the letter of what the court ruling was, and that's what they think they can do. They can't go beyond it, or they don't know how to renegotiate it, and it might work for different ages of the child. So what happened for a child at 3 might be very different for a child at 6, and again when the child gets to 9. And so there's constant change in the lives of the parents.
I think the information thing is critical, because we would have women coming on to us saying, he hasn't paid his maintenance, so I'm not letting him have the child, say, between 3 and 6. And we would say, well, it's a court order. You can't, and so I think people sometimes don't realise that there's access is different to maintenance, the way the law is set up. And the Australian government, this stuff is international. It's about people not under, because, you're not a lawyer anyway, and so you only, when life circumstances happen, you find yourself in this context. But the Australian government had a massive national information campaign where there was, around a public information campaign. It targeted, obviously, the general population, but also we have a problem. We find it daily with people coming on to us saying, I went to the Garda station, I'm the sole guardian of my child, I wanted to get a passport signed, the guard refused to sign it. You see it in judges' decisions of where, I'm a guardian of one child, I'm not a guardian of another child. So this really lack of general understanding around the concepts, and this ties back into what we said earlier about what the Law Reform Commission recommended, about simplifying the concepts. That it's about the day-to-day care, it's about the language we use around these concepts. Just another thing I want to mention is that, Claire, in relation to what you said earlier about the voice of the child, one of our recommendations is in relation to this form. It's called the Statements of Arrangement for a Child. There's 27 questions on it. It's part of the Child and Family Relationship Act. And the idea was that all judges at district court level should be using this. It asks a broad range of questions around issues to do with domestic violence, criminality, what other children are living in the house, because lots of people now have children by different parents and stuff, so the whole structure of the family is different. And this is meant to give the judges then a very kind of an overview of this particular family. And what we found is that this is being used in Dublin and it's being used in Cork. And once you go outside of Dublin and Cork, it's not being used. And so what we're saying is that all district court judges, this form should be compulsory, because then it means they have to take time and look at the family, the particular family.
Mary, and before coming back to you, Deputy, I'm going to take one more. Maria has indicated, please.
Maybe just to note that at the moment, under an EU directive, the Brussels II bis directive, there is a recognition and enforcement of family orders between European Union jurisdictions. So with Brexit, we're now facing a scenario whereby an access or maintenance order made in a court in Northern Ireland where the family is living in the Republic, there's an issue there as to, in terms of there won't be post-Brexit the mutual recognition that has existed to date. So obviously new procedures will be needed. We'll be going back to a previous way of running things. I know.
Fair enough.
So there are other mechanisms, but just to bring that to the committee's attention. I mean, just maybe while I have the floor in relation to this, I suppose the issues under Brussels II. So you've got the recognition and enforcement of orders. You also have the placement of a child in care in another jurisdiction. So obviously Ireland places quite a number of children in the UK. You also have issues around parental abduction and transferring of cases where families may move, but the case is more appropriately heard in another jurisdiction. So under the European Union, the Brussels II legislation, there's very strong procedures in terms of the voice of the child, requirement to hear the views of the child, and also very clear timelines. And so there's a real loss when we now won't be able to use Brussels II in relation to the UK jurisdiction. The UK will now be third country, so it will fall outside of that. So.
Back to Deputy Daly.
Yeah, I mean, just in terms of, say, shared parenting arrangements and the shocking figures of how few children end up in shared parenting. So I suppose I'm curious if is this a practical question by the court, sort of, look, because when it's separation, one lives in the big house with the kids and one lives in a one-bedroom flat somewhere or whatever because of our commodification of housing in this state? Or is it a practical thing? Or, do middle-class families don't particularly fare any better, really, do they, in the 50-50 parenting either? Or is it a cultural problem in this situation, or what? Why don't we have, in a post-separation era, sort of more shared, equal 50-50 parenting or whatever? I mean, obviously it can't be divorced from the economic situation either, but...
Is that your concluding question?
Well, I'll just throw in,
No,
okay, I will on this one, let the others
say,
Your
four colleagues sitting who have yet to participate, and we're at 12.
Yeah, okay, I will make that my last one,
You're making that your last. Thank you. Sean.
Chairman,
and then Demi.
my colleagues might say, I think a lot of it is just the reality of people's lives, and I don't think there's any difference to what happens to middle-class people or other people. I think the court has the unenviable task of dealing with the facts of each particular case. And as my friend Dr. Fennell said, there is law in this. There is also the facts of each case determine to a large extent certain practical outcomes. And in a lot of cases, and while the traditional model is changing, one parent, traditionally the father, but that is changing, may well have workplace obligations, which means that he cannot effectively take up equal parenting, even if both parties want that. And I think a lot of couples, be they in marital relationships or non-marital, if the conflict is minimised and the assets and the maintenance issues are resolved, do try to accommodate one another. But I think a lot of it is the practical realities. Then you do have the difficult cases, which is a smaller subset where they're in conflict, and then thankfully the smaller subset again where you need the Section 47s or the Section 32 reports. But I think in a large number of cases people do come to an accommodation, but they have to just take into account the realities of commuting in Dublin if you live in Chapelizod and you work in Baldoyle or whatever it may be. I don't think my colleagues would disagree with that.
No, I agree with that. I think a lot of it is a concept of shared responsibility between busy parents nowadays, and I do think that the courts tend to take a holistic approach to the child's circumstances, and it may well be that in some cases that one or other side isn't actually seeking a shared parenting arrangement because just feasibly that won't work. So I would echo what Mr O'Caoláin has said in that regard.
Thank you for that. Damien, please.
I think it's important to say that from the onset that shared parenting doesn't mean equal parenting in that definition, and so it doesn't mean 50% of the time, and that's often not in the best interest of a child either, and so we need to look at that. But there is serious issues in relation to for fathers, well, primarily fathers it happens to be, but the non-resident parent in terms of access to housing. So that's another major issue. If you've got 2 children, you live and you can't get on the housing list for a 2-bedroom house, or you just can't get on the housing list because that's already allocated to the primary carer. So there are major issues in that regard. But shared parenting is much more of a concept about, as somebody said there, it's in relation to participation in the bringing up of the child in a much more equal way, and having a say in that child's life in a much more meaningful way. And there has to be a promotion and dialogue about what this concept means and how we have to try and enforce it. So it's not just about parenting programmes, because what tends to happen is if a child's going off to the dad for 2 days a week, the dad, unless the dad and the mum are having some dialogue, they can parent the child very differently on the 2 days that I have the child than when it goes home to the mother. And so what shared parenting is about is an agreement about how we're going to do this, and a concept about bringing the 2 parents together.
Indications from Rushing and Mary also, is that right? Well, I'll take Rushing just for she was just before you, Mary. Please.
Right.
Just if we can just.
I know I'm going to keep it tight. Yeah, no, I am loquacious, but I'm working on it. The Swedish Research Centre CHESS, CHESS, they've come up with a definition of shared parenting where the non-residential parent has at least 30% of the child's time per week, and that's beginning to be an accepted definition of shared parenting. Because we're a bit data free at the moment, so I'm just going to give a stat. In my 1,200 cases that I observed in the Circuit Court, 1% of children resided with both parents under 50-50 parenting arrangements. So that was the equal parenting time piece, right? I think I just want to say something very quickly in terms of most family law cases take place in the district court. There is no complexity of law in the district court. There is no issue with quantifying maintenance. It's not how I feel about the money, it's what are the numbers. And we're number bereft in the district court. And parenting should be under guidelines. So we should be using structured systems. These are not things that should be argued about. These are not legal complexity. Most cases that have those, they can be dealt with and they're more rarefied. The vast bulk of cases do not have any legal complexity.
Mary.
Just to say that there is a class dimension to this. The international research shows this in terms of shared parenting. There is that if you're poor, clearly there are a whole range of different pressures on you. And again, referring back to the Australian model, it's about resourcing communities. It's about resourcing family centres where they become, points where people can go. It's also, you asked earlier, it's about changing how we think about this and about how men think about their roles in relation to children and how we think about the family, and that the mother doesn't, the buck doesn't always stop with the woman. And it's about changing that whole structure about it, and also resourcing poor neighbourhoods and poor communities, that the facilities are there for them. And it's about your public services. It's about proper services for people.
Thank you, Thank you, Deputy Daly. We're now going on to Deputy Donegal O'Leary, please.
There's an awful lot of ground I can cover. I do have 1 or 2 more questions, but I suppose there is so much that could be asked, really. I suppose one of the first questions that just arises, I hope you don't mind, but just in relation to Roisin's proposition, I found your presentation and your answers to the question absolutely fascinating, but I suppose I'm interested, the point that you've made in relation to alternative dispute resolution and mediation in relation to domestic violence. I mean, that is a point that I suppose the Rape Crisis Network were, I suppose, at the last hearing said that they didn't favour it in those circumstances. So I suppose I might ask the other 3 groups that are represented here for a response to that. Like, I mean, do you believe? And I've listened and I'm open-minded. I've listened to the arguments made. I suppose my gut would be, maybe hesitant, but I would be interested to hear what the other organisations would have to say in relation to the use of mediation, alternative dispute resolution.
You're saying this without rushing? And because we're looking for a reaction to what you've said. We'll take one from each of the three groupings. Sean, you're indicating, Carol and whomever from Troer. So, Sean, please, first.
The Bar Council is very much in favour of alternative dispute resolution. And I think it must be borne in mind that alternative dispute resolution is not solely limited to mediation. There is collaborative law, which is not really developing to any great extent at the moment. There can be possibly, and I'm saying possibly, arbitration. And just on that, the Bar Council is engaged in a pilot analysis with the Law Society and the Chartered Institute of Arbitrators to see if there are certain aspects of family law, discrete issues, which, without impeding on any constitutional boundaries, could arbitrate in certain discrete matters of family law, which might reduce costs and shorten cases. That's in its early stages. We have a dispute resolution centre in one of our own buildings in Church Street, in the Distillery building, and while at the moment it's mainly used by inquiries and commercial groups, it's there. We spent money on it and fitted it out, and people can use it for mediation or arbitration in family law or any other area. So we're very open to it, but we're acutely conscious, and with no disrespect to Roisin, who is an admirable person, mediation is not the panacea. This is a wide panoply of cases. The numbers are big. There are just a lot of family law cases where the parties will not be willing to engage in mediation. You can try, you can introduce them to it, but mediation by definition requires two consenting parties. And without that, mediation becomes another layer with an additional cost and a delay factor before you move on to the court system or arbitration. At least with arbitration, the court system, there are defined processes. In the court, the judge can call the shots. In arbitration, the arbitrator, albeit I accept in family law that's very limited. So I think mediation certainly has a role, probably needs a greater role than it has.
Just, I do want to clarify, I suppose the question was specifically...
Sorry.
Yeah, its appropriateness, I know there's a role and you can agree or disagree on the extent of the role. I'm sure I believe there is a value. But my question is on the appropriateness of the use of, and I appreciate it's not limited to mediation, but of mediation and alternative dispute resolutions to instances where domestic violence is an issue. That was my question.
Well, I would differ from Dr. O'Shea on that. There may be some analysis to be done. There may be a learning curve. There may be cases where it's appropriate. But I'd be more in line with the Rape Crisis Network that, in general terms, domestic violence or abuse cases would not be appropriate to mediation, I would have thought. In my experience, and my colleagues would have greater experience of this at this stage of my career than I would have, but in my experience, the situation is so fraught. Even if it is not, as Dr. O'Shea rightly says, it's not necessarily and rarely, the demonstrable physical violence, but other types of abuse. I think it's possibly dangerous. I think the person who is the victim in that relationship could come out the worst, particularly in mediation where there's no lawyer-assisted mediation, but just a mediator. There's anecdotal evidence that mediation with a mediator and no lawyers can lead to the dominant spouse or partner engaging effectively in bullying at the mediation process. Lawyer-assisted mediation is slightly different because each person has a protector with them. But I think in general terms, I would be against, and my experience would tell me to be against, mediation in domestic violence situations or abuse situations, at least in the early stages.
Going on to Carol, but I'd just like to indicate to Roisin, I will bring you in at the end. I mean, the response made my mind up for sure. Roisin, you're back on notice. Carol, please.
Yeah. Well, this does not really arise in child protection proceedings where, domestic violence certainly does arise in child protection proceedings. Of course, child abuse sometimes arises in child protection proceedings. But what is involved then is the state intervening in a family to limit or remove constitutional rights from family members. And that is a totally different type of proceeding than private family law. And as I said earlier, I don't think it appropriate that mediation exists there. There is a second layer, if you like, of issues that then arise in childcare proceedings where both parents may want to have access with their children, they may have views in relation to the education of the children or in relation to their health and so on and so forth. And I certainly think mediation is very important there. Again, the domestic violence issue is unlikely to be one of the issues that features in that layer of consideration. And I don't think it's always appropriate that judges be asked, to decide on whether or not the child goes to this school or that school, when there could be a mediated discussion around it, or equally whether the Child and Family Agency allows access on a Wednesday or a Thursday. There are those kind of issues which are very, very suitable for mediation. But the domestic violence issue will have probably featured in the order that is made about the care of the child by the court.
I do think it's a very important question, and I think the research, there is, as Roisin has said, there's quite a divide even in the mediation and in research that's out there. But Tror comes from the position that the right of a child to know and be cared for by both parents extends beyond, the issue between the parents, and where issues, when it impacts on issues of access and custody, we do think that mediation can be appropriate in terms of where there's domestic violence, if there's not a child safety issue at stake. It all depends on the training and expertise of that mediator, and there is training and expertise in mediation that would be able to determine whether one parent was been dominant or wasn't engaged. And as Roisin has pointed out, mediation doesn't mean two people in the same room. It can be people at different times, in different ways, and in different spaces, but that they're coming to some agreement around how they're going to access the child and how it's not going to impact on the safety of the mother.
Just before bringing Rush in, and just to explain that Dr. Sarah Fennell had to leave. She has court responsibilities to address, and she had flagged that up to us earlier. Rushing, right of reply.
Okay, so first of all, I would say that I like to speak from empirical data. So if you make a statement, Sean, prove it. That's what I'll say to you. Is because I personally know of no data at all anywhere in the world that would support what you said. In other words, that there is proof that where there's a non-lawyer mediator scenario, that there is bullying in the mediation process. So my view on that is that is anecdotal, and I personally, now if you can find the evidence, I'm wide open to looking at it. But at the moment, the project that we are running, it's a research project, and the reason we're doing it as a research project is to tease this whole space out and see, can we run the domestic violence piece? Now, what do we mean by domestic violence? We mean when there's a domestic violence allegation. So psychological abuse, coercive control, right through to physical, right? So it's a huge area, right? We're not saying where there are court orders in existence to say, as a result of physical violence, we're not saying that may get screened out. We've got a screening process. So we screen the clients before we even do the mediation. But most cases where there's domestic violence allegations can be mediated. In the 50 cases that we've done so far, 25% of those hit the domestic violence allegation space. We're not on our own in this dialogue. This is happening in other countries, and other countries are trying to figure out how do we do it best. Drugs and alcohol are the two biggest pieces, and from that flows the other problems, including domestic violence, that I'm seeing in the courts, both the circuit court and the district court. The mediator that Sean refers to is a mediator that is doing a really bad job. The mediator that allows a power imbalance to happen, the mediator that allows a dominant personality to in any way bully or control the process is doing a really bad job. And I think we need to put it into context. I'm probably being a bit hard on Sean, but the context probably justifies what Sean has said. And the context is that in Ireland we developed family mediation uniquely different to any other jurisdiction that I looked at. Why? Because we began in the 1980s, Catholic ethos, coming from the Accord background, and we actually developed a form of family therapy mediation, unique to this country. We do some great stuff. This was incredible in the 1980s. No other country started off a state family mediation service. We did it in Ireland. It was incredibly innovative, but it hasn't evolved enough. And what I'm saying now is that therapy process was based, probably what Sean is feeling is the norm, isn't the norm. That process was based on the two people being in the same room at the same time with a single mediator who was essentially doing a form of family therapy, allowing them to vent, get all the issues out, that kind of thing. The process that we're running is by gender, co-mediation, so male-female mediators, so men don't feel that women are all over the process, so male and female, by gender, and separate mediations. We're calling it parallel mediation. So when people are in conflict, you initially work with them separately. And we get 10 days we see them, and we try and get the first parenting agreement within another 10 days. And that first parenting agreement is 6 weeks long, because everybody stays in that fight or flight space, and during that 6 weeks, we try and tease out, test run. And before they get to the end of the 6 weeks, we take them on into a 3-month. Before they get into the 3-month, we take them into a 6-month, and then we move them on into a year. And so each agreement evolves with the family. And where there's domestic violence, allegations I'm talking about, we try and work it out. We try and figure it out. 5 of the 50 cases were domestic violence allegations that were subsequently proceedings, an application was made, and then those 4 made undertakings through the mediation process to the court where the judge accepted undertakings. Now, an undertaking is where a person swears on oath to the judge to the same effect as a protection order or a safety order.
Okay. Now, I'm not going to open up a dialogue between the panel because you're engaging with the members. So I think the answers have been given as the requester deputy had sought. I return to you, Dominic.
I do want to explain, just because I think it's important that, even though, look, not that I want to particularly call it controversy, I think this was a point that was in a submission last week, and I suppose we all took it as a given. So, and it hears and it sounds maybe self-evident, whereas I suppose if an alternative point of view is brought forward to the committee, I think it's important for the benefit of our report, for our benefit, that is fleshed out and that we understand what the two different points of view are. So I'm not looking for dispute or discord in relation to that. My next question in relation to Trower, I suppose one of the points that and anyone else as well, but I suppose specifically for Trower for the minute, and I suppose it goes to the discussion around shared parenting. I raised the point last week, the lack of contact centres. I have some experience. I mentioned at the previous meeting my knowledge of a service in my community that was, I suppose, limited to child protection referrals. Right, it no longer takes referrals from the family courts due to where there's not a child protection issue, due to lack of resources, and I suppose my familiarity with this beautiful facility, really excellent. Now, having said that, I suppose as against that, I suppose I'm weighing both considerations up in my mind and my belief that that looks like an excellent facility. But on the other hand, I have come across people who said that, like, to try and engage their children in an environment like that is very unnatural and it's very difficult. And if you're doing that against the context in which you believe that you're being observed and notes are being gathered upon you, and I'm not talking about the child protection issues, because obviously that's a very discrete category there, but more generally where there might be use of a contact centre, that I suppose, what's your view on it? And, like, I mean, are they worth pursuing in spite of the fact that they mightn't be the most natural engagement? Or, I suppose, have you any other observations on the value of contact centres? Okay, Deputy. To Trower.
Okay, yeah, it's a very good question, and it's something that we talk about in the broader submission around the lack of contact centres nationally available. It is an unnatural setting because of the very facts you described. It can feel very unnatural, but it is a process. It's part of a suite of opportunities that can allow, particularly the non-resident parent, to start to engage with their children again in a safe environment. But it needs to be able to extend into other services that are possibly there. There is a huge dearth of available safe contact centres and contact points available for parents, and this has caused huge problems, huge stresses, and appropriate people to be able to be that supervised place in non-child protection issues. So we think there's a real need for more resources put into that contact centre space, and to thinking about the longer term as people move out of that into much more shared parenting arrangements.
Okay. Does anybody else want to add anything to that, Mary?
Just to say that as well, when people get involved in this system, particularly poor people, people who have literacy issues, it's this huge kind of daunting thing. Like you said, they're suspicious of the state, they're suspicious of the agencies, and so you have all this kind of added trauma onto the whole thing. And so this is why we're saying about that. If you're thinking about a service that works, you know, it's properly resourced, it's professional at every level. And it's child-centred and it's family-centred. It's about supporting people to get resolutions, but you have to resource it. You have to fund communities, you have to fund childcare, you have to make the labour market accessible to women who are parenting on their own, you have to make it accessible for fathers so they can have access to their children. You know, so it's a whole suite of things around properly resourced, funded public services.
Thank you, Mary. Donncha, please.
I might just add, maybe Dr. Coulter, I don't know, I suppose the child law sphere is different, and there is probably slightly more funding, but still probably inadequate.
It's very, very inadequate, and in fact, access, I think, can be nightmarish for parents whose children are in care, because there you do have. If it's supervised access, now of course not all access is supervised. It can be, you know, in a relative's house or even going home for weekends. There's a lot of variation in the conclusions, especially in a situation in which a family is going to be reunified, and that does happen as well in our childcare system, I think a lot more frequently than in the UK, where after a period in care, children may go home and then they will lead up to that with weekends. I'm not talking about that, but where the CFA is organising access and there are and can be logistical difficulties, the access can take place in basically an office. You know, it's not always appropriate, and if it's supervised, people are being observed, and if the final order has not been made, and the final order will be many months after an initial interim care order is sought, they feel that every single thing they do with their child is going to come up as evidence in the ongoing child protection proceedings. So there is certainly, I think, a need. Actually, contact centres, as have been described, will be a huge improvement on what exists, I think, for people in the child protection system compared with what they often experience now.
Yeah, for the interest of efficiency, of 2 observations and 2 questions, I'll put them all together.
Please.
We can go around the houses.
That's good. And then we're going on to Senator Francis Black and then Deputy Mick Wallace.
Just for the interest of the witnesses or whatever, like that's an issue I've raised, the whole issue of contact centres. And you may be aware, you may not be, but like TUSLA and the court service are batting it back and forth anytime I raise it with them, and each says that the other is responsible, and nobody seems to want ownership of who should pay for these contact centres. That's just by way of an observation. I'd also add, because I don't need to elaborate on it, but like my experience of people contacting me is very similar to Deputy Daly's in relation to the Section 47s. People feel that there's a lack of regulation around the experts that are involved, and that there's a lack of transparency, and that there is that inequality of arms that I think some of you have referred to in your presentations. My final 2 questions, I suppose I wasn't actually aware that, I suppose, God, it comes into absolutely everything, but Brexit and mutual recognition of, it's incredible how much it really filters into things, mutual recognition of arrangements, and I suppose we've been debating these last few days essential legislation for if there is a hard Brexit. Like, I mean, I suppose the question that occurs to me is, should we have that in that legislation? Should we be putting provision in this legislation that we're dealing with this week and in the coming weeks in the Shannon to provide for, in the event of a hard Brexit, for mutual recognition of arrangements in family courts? My final question there is just, and again it comes from the point that Troll made, and Deputy Ó Caoláin asked it, but I might ask in a more direct way. He asked what would be the potential implications. I suppose to ask the other 3 groups, or the other 2 groups, and Dr. O'Shea, do you agree that with a change to the law that would provide for automatic guardianship rights? supposed to ask him more directly. So thank you very much.
Or Carol, which of you wanted to take the Brexit piece first?
Yes, it isn't something that we have given a lot of consideration to because it doesn't arise enormously, but there was a case only last week where one of our reporters attended where a young child was in care, the placement had broken down, the child was in care having previously been in the care of the mother. The father was willing and able, well, I'm not sure about able because the court hadn't a chance to look at it, but certainly willing to take responsibility. But because the father was not a guardian, the court didn't have the legal basis to consider the father's position, and because he fell just outside the threshold for legal aid, he wasn't legally represented, and the issue of guardianship could not be pursued as it should and could have been in the district court by a lawyer representing him, there and then. That's clearly one instance where that gap was very detrimental to the welfare of the child as well as to the rights of the father.
Was there a Brexit? Had you a particular question, Deputy? Please, Maria.
Yeah, sorry. I mean, I think the difficulty from the Irish perspective is that the EU regulation, you have to be an EU member, so there's actually not, there's not a whole lot we can do in relation to the UK now becoming a third party. Yeah. There is the prospect that the EU regulation will be amended to allow third parties to engage, so there may be something in the future. I mean, I think maybe the Bar of Ireland representatives might mention as to what might happen in terms of the courts, the closeness under the common law of the courts and how they may engage. But I think that there is at the moment maybe uncertainty is probably the best way as to what will happen in terms of some of the arrangements that we have at the moment where we use a piece of legislation. We'll now go back to maybe bilateral or other arrangements, and certainly there is a sense in some of the High Court cases around secure care, the special care orders where we place children from Ireland in the UK. There's a sense maybe there of the places not being available. There's an uncertainty of maybe placing children, maybe using other legislation, wardship and bilateral arrangements, going back to previously what we had before the EU regulation. And I suppose the reason we're raising it is that the EU regulation has lots of safeguards in place and it has its clear structure. So I suppose we're going from a position of clarity to uncertainty, and so I'm not 100% sure what, from a legislative perspective, can be done in the immediate, but we could come back to you on that.
Sure. The other question, I think, directed to yourselves in drawer. Ruth, would you like to, please?
Our difficulty with the provisions of the Child and Family Relationships Act is that automatic guardianship, in inverted commas, is provided for if the unmarried father has lived with the mother of the child for 3 months before the child is born. So at a very practical level, there are many young couples from low incomes who never live together and have a child because they've no place to live together. She's with her family and he's with his family, so there's no question of that applying. Secondly, even if they did live together, there's no formal registration of that guardianship because they can only be established through a statutory declaration, which is the property of one or both parents, but it's not a public document, it's not a public record. And at a more fundamental level, we have a problem with that provision because essentially it's defining the criterion for guardianship is the relationship between the mother and the father, the 3 months cohabitation, not the relationship of the father to the child, as it would be if they were married. So we really do think that there is a deep injustice there which should be rectified, and in the normal course of events, guardianship for unmarried fathers should kick in if they sign the birth register. Now, people will say, well, what about the domestic violence? But domestic violence is there in married couples as well as unmarried couples. So that again should not be a criterion as to why a father should be denied guardianship rights over the child. If there's some abuse there of those rights, well then of course they should be removed. but the assumption should be that the father is the guardian of his child, whether married or unmarried. And Thror would like to see that changed, the law changed to recognise that right of unmarried fathers.
Thank you. I have indications from Rushin and Maria. I'll take you in that order, and then Damien on the same. And then we'll come back to you then at the end. And Sean.
So to the 2 points that you raised,
and just if I could say,
sorry.
I am mindful that Senator Black is under some other pressure as well.
Okay.
So keep it short.
So in relation to guardianship, speaking with my research hat on, I can speak for the researchers that I work with. We would support Thror's proposition that registration of the birth certificate should be an automatic. And I think the key piece we'd also agree with is that the rights should not be based on the nature of the relationship between the parents, but it's the right of the parent who produces a child, creates a child. So we would say, we would say that they're not allowed to speak over there, are they?
We don't even see them. Come on, we keep going.
So we would actually, as researchers, support Thror's position. I think we do have to have that legislative change to have automatic guardianship. I think it may deter some mothers from putting the name down of the fathers on the birth certificate, but that's another argument. The second piece to what you were saying was TUSLA operate the family resource centres. They're under their wing. And the family resource centres, the Kilkenny one trialled contact on their own initiative. There's 120 of them across the country. I don't know if you know that, but they kind of have their own little bit of leeway to do their own things to a certain extent. So the Kilkenny New Park Close Family Resource Centre trialled operating as a contact centre. And what it meant was that staff had to volunteer to come in on the weekends or after hours to do that contact piece. So what I would say is the 120 family resource centres have the facilities to operate as contact centres, and they also took part in a pilot with Bernardo's, and they were some of them were contact centres. So again, go back to my original thing. Let's take existing state resources. Let's go and look at the TUSLA 120 buildings. And if it's a question of funding staff who are already on salary to stay a bit longer, maybe we could figure that one out. And I think, our family mediation project, we've got a 57-page handbook. It's a model, and we want to give it to the state and roll this in 2020 across the 120 family resource centres so that mediation can sit in the middle. A state offering, I'm not talking about private mediation, I'm talking about the state offering, sit in the middle of the resources within the family resource centres, which are extraordinary. They have everything a family needs, and link it to the courts. So if you need that enforcement piece, link it up. The Mediation Act does that. Thank you.
Thank you, Rishin. Maria is next.
Sorry, just to mention that there's 2 Hague Conventions that will be of use in terms of when the UK is no longer covered under the Brussels II. So there's 2 Hague Conventions that will be used.
Thank you. Sean, please.
Yeah, well, on the Brexit issue, I was just going to say that this is something that has come up for consideration and is causing some disquiet. In answer to Deputy O'Leary's question, I don't think it's necessary for it to be in the current legislation which is going through the Oireachtas. Without getting, I suppose, too technical about it, because it does get very technical, there is a 1996 Convention on Jurisdiction, Applicable Law, Recognition, Enforcement and Cooperation in respect of parental responsibility and measures for the protection of children. We all call it the 1996 Convention. Now, I think it is to be hoped, well, the UK will continue to apply that convention. But within the EU, the Brussels II bis takes precedence. If the UK is no longer in the EU, well then it arguably will not apply Brussels II, but it will apply the 1996 Convention. And I think that will resolve a lot of the immediate issues until some form of bilateral arrangement between the UK and the European Union emerges. So I don't think it's a cause for alarm bells, it's a concern rather than alarm bells. The issue might be more as the years roll on. If the UK is not going to apply decisions of the Court of Justice of the European Union, then we may get a greater divergence. Like at the moment, there'll probably be no great divergence, and probably for the first few months or maybe even years, there may be no great divergence between what would happen under the 1996 Convention and Brussels II bis. But that divergence over time could emerge. And that could cause a particular difficulty, I suppose, more for this jurisdiction due to our close proximity and historical connections to the UK. There is, I think, mention was made of the transfer mechanism under Article 15 of Brussels II bis. And where jurisdiction lies with the habitual residence of the child, but it can be otherwise in exceptional circumstances. And there could be a transfer to a court better placed if conditions are met. Now, I think, again, the 1996 Convention in the short term will work out fine, but following withdrawal, some parts of Brussels 2 bis won't apply. And I'm just looking at notes I had here on this issue. There's also, in child abduction cases, there is a 1980 convention, which I think is the other convention you were probably referring to, on the civil aspects of international child abduction. And again, there's a broad similarity, but there is a thing called a non-return order, which ends the case in that convention, whereas under the EU law, Brussels 2 bis, the court of the country where the child is residing must send the papers to the court of the country the child has been removed from, and that second court can order the return of the child. Now, that again is a minority issue, but it doesn't apply. The 1980 Convention doesn't have that. So there are issues, but I think the Department of Justice has looked at this, and I think there is a hope that in the short term the divergence will not be big. Immediately it won't be, but over time it could emerge. And there is the hope that because of the connection that has been built up, each jurisdiction has judges who deal in this area, and they don't just wait and talk to each other by megaphone. They phone each other, they email each other, so there's direct contact between the judge with responsibility for this at each jurisdiction. They have conferences, they get to know each other, so there is good rapport. And I suppose particularly with the UK, where they can speak in English to one another, I think in the immediate term good sense will probably prevail among the judiciary on both sides. I suppose it's the importance of contact connection rather than megaphone diplomacy. A residual area where there could be problems is the enforcement of maintenance. Orders. Now, as I understand it, and I'm subject to correction on this, there is not an avalanche of maintenance orders. I would have thought the figure was higher. I think it may be in the region of 250 to 300 a year. So we're talking approximately 20, 25 a month. There will be a short-term immediate problem if they're gone on the 29th of March. But as I understand it, again subject to correction, the Department of Justice is looking at some form of statutory instrument which will resolve that, but they're a bit... it may not be there on the 29th of March, but I think it will be there in May or June. So I think we will get over these things. Maybe in a year or two's time you might invite us back here, or there may have to be other legislation. But I think, Deputy, for the moment, I'm not saying it's plain sailing, and there are concerns, but I think they can be dealt with in the short term.
Now, there are two other indicators in relation to this, and I do appeal, because we have to vacate here in under 3/4 of an hour for another committee who take over. So, Damien and Rachel, last two responses to Deputy O'Leary, please. Very
briefly, because Sean mentioned the issue about maintenance, and the other one that I was just going to talk about was very briefly the Good Friday Agreement, which allows aspire to have parity of rights between citizens on both parts of the island, and the need for protection in that. And currently it's not even enforceable, where an unmarried father in the north of Ireland will have automatic guardianship rights. Literally over the border, a non-married father won't have. So there is already, we can see that where we don't have parity of rights in relation to where you live on this island.
Thank you for highlighting that. That was an issue we addressed here in some considerable detail only some weeks ago, and it remains a huge concern for all of us. Rachel, last point to Deputy O'Leary.
In relation to the guardianship, I think there needs to be more talks about it and in depth. I think just to clarify, I think the father will only be automatic if they've lived together for 12 months, including 3 months after the child was born. But I think if automatic guardianship comes about, I imagine what's been debated before the issues is that if a father who is not involved, who does not wish to be involved, any issues can arise in terms of like that getting a passport, or medical issues if you can't track down dad, or you can bring an application to dispense with the consent, for example, for a passport, but if you can't serve dad, you don't know where dad is. So I think there are some practical issues in relation to that, not just, I don't disagree with Troy's position in relation to it, but I do think there are some practical difficulties there.
Thank you, Rachel. Thank you, Deputy O'Leary. Senator Frances Black, please.
Very much, Caoimhghín, and I will try and keep it as short as I possibly can. I totally agree with Clare. It's so depressing, to be honest with you, and like, and I said this last week, it feels like we're living in the dark ages. That's what it feels like. It's like when we're hearing all your presentations, you know, you could go back 50 years ago, and it's just hard to believe that it's going on, honestly, that it's going on in this day and age. And I can't even imagine what that's like for the families and the children that have to go through that trauma, actually. It's a huge trauma. And, you know, and I suppose the question I have, and again, you know, we could spend the whole morning, you know, just talking on various different issues. Like, we are living in the dark ages, and why is it that we are, you know, still here? I mean, that's one of the questions I'd like to ask with regard to, you know, the other countries. Why are we not up there with other countries? And, you know, a part of me knows, you know, but there's another part of me that would just like to hear maybe some of your opinions on that, as to why we're stuck in this really awful place. That's the first question, and I'll try and put them all together, Caoimhghín. And I want to come to you, Roisin, because Dr. O'Shea, the area that you're talking about is an area I have a very strong specific interest in. I work with families myself, particularly around, you know, addiction, and I, you know, I work with the trauma of it, and I know that, you know, the work that we do, we don't work with the person in addiction, but we only work with the families, and I know that we can, you know, kind of prevent you know, a family going down that route of courts just from the work that we do of empowerment. And, you know, for example, we had one woman who had left her home because of her son's violence, and then she came to us, and, you know, as a result of her getting a really good understanding of how to cope with it, she's now moved back in, and, you know, her son is not, you know what I mean, it's amazing what you can do, and I'm sure you're very aware of that. But I am also very aware of, you know, say, bad therapists and you know, and bad mediators. So I just wanted to kind of question you a little bit on that, as to how do you, you know, prevent, how do you stop, you know, that, because that is so, you have to be so careful in an area around all of that. And, you know, if women are coming to you, or men are coming to you around domestic violence, and there's so much shame around it and all, you know, so is there something in place around it that, with regard to what your work, the great work that you're doing?
Well, there were two questions in this, and I'll leave it open to the panel. We'll start with you, Roisin, and if others would like to indicate,
you won't be able to
please.
stop me.
Well, I might have to, because the clock might dictate.
This is such a serious way. Look, sometimes you have to laugh because you'd cry all day long. I would cry every day I go into a courtroom if I didn't have a really good sense of humour to keep my headspace right. First of all, I just want to tackle the mediation piece. Totally agree with you. There is probably a lot of bad mediation going on. It's probably why Sean has a fairly negative view of some of the mediation, and I think you could be right. Okay, I'll give you that. How do we fix that piece? We need the mediation council to come in. We need. I, as a user, tomorrow morning. First of all, let me put it this way, Francis. You could go out and stick a plaque on the wall and call yourself a mediator right now. It's like the Wild West of. Remember, the auctioneers used to be in the same space. Sorry, Mick. No, you were never an auctioneer, were you? No. Okay. But basically. But basically, right now, anybody can stick a plaque on the wall and call themselves a mediator, because there is nothing to say otherwise. We do have a Mediation Act, and it has now set the groundwork for where we are in the space. But we need the Mediation Council, because a user who's thinking about using mediation, particularly coming from a very conflict space that you're talking about, they need to know the competency of a mediator, the training standards of a mediator, that there's a complaints procedure. There's somewhere they can go if the mediator does a bad job. So if they meet Sean's mediator, the one that allowed the bullying, in all seriousness, they need to have a forum that they go make a complaint about the negligent behaviour of that mediator. It's really important. We go back to what I said at the start of what I was talking about. The earliest intervention possible. Francis, you've hit it on the head. It's exactly... Sorry, Deputy. I should be calling you Deputy. Sorry. Okay. That's exactly how we should be thinking. If we think about getting to families, or rather, if families think about and know that we, the state, have support systems, and they think in a new norm that, oh, we will now go here immediately because this... We go to this mediator, say it's state, and they go into the FRC, and the mediator starts working with them, and the mediator sees addiction problems. mental health problems. Mental health is popping up in so many of the cases I'm working with. And then that mediator can reach out within the FRC and organise for that family or that parent or that child to get that support in the FRC rainbow of resources. And as you said, I love the way you phrased it, because like when you get to people that early and when you help them that early, it actually stops the conflict beginning to get legs and walk. And I think earlier one of the pieces here was that we all know that people don't want to be in conflict. We do all know that. What I would disagree on is that once people get into the war zone of the court system, I did myself, you go to war and you're encouraged to stay in war and you actually will keep fighting. I did. I'm going to hold my hand up. And so I think what we have to do is try, yes, this whole discussion is about reforming the family law courts. I say again, we're starting the conversation in the wrong place. We start about how do we keep people out of the family law courts and how do we give them appropriate supports, early intervention.
Maria was next, and it's not just about the courts, obviously it was the system was actually the word we employed. Maria.
Great. So I've just two comments. One is you asked, how can we do it better? How are we here? And so maybe just to make a quick comment to bring us back to the kind of where we started, maybe in the proceedings, is around the need for a specialist court. So most other jurisdictions in relation to child protection would have a specialist court. So that really is. I know we talked about facilities and buildings, but if we can kind of put that aside for a minute and think about the actual management of the system, so that if you have a unified, common system approach in relation to child and family cases, so both the private and the public cases, that would make a huge difference, because you then would be able to have common rules operating in those courts. So at the moment, the district court is 24 separate courts with their own districts with their own rules, having multiple courts within them, but 24 districts with their own set of rules. So good practice that may exist in one place isn't able to be transferred to the other. So a common set of rules operating across the system would make a big difference, and would address some of the delay issues that we see. Well, it's not necessarily delay, but it's duplication. So you will have a hearing on the same issue across the country, continually issues being relitigated. Do you have access to Garda DVDs in terms of evidence? How do you deal with hearsay evidence? Constantly relitigated because it's operating at the district court level. Also, if you have this common unified court system, you would be able to move cases from the district court up to a higher court when necessary. So the work that the Childcare Law Project did in relation to complex cases, you could clearly see that the district court wasn't equipped, both in terms of its rules, in terms of discovery and other rules. It didn't have the time. Those cases should have been brought up. I'm thinking in particular of cases around child sexual abuse allegations, or other cases where there's a lot of experts being brought in and assessments needed. So I suppose that's just one thing, is just to go back to that the actual unified approach with a flexibility within the court structure would make a huge difference. The other thing then, just a slightly separate point, is we've talked a lot about early intervention, so preventing people getting to court, but in the child protection area what's really important is how to get children from care back home. So one of the issues of good practice that happens in other jurisdictions is a family drug and alcohol court. So the idea is that often if a child goes into care and the core issue in the family is an addiction issue, the likelihood of reunification is not great in those cases. So to improve the likelihood of reunification, you work with the parent around their addiction issue. So you bring in a different model where it's more a therapeutic judicial model, where the judge and the parent engage around their addiction with the goal of getting the child back home. So just to bring that to your attention.
Thanks, Maria. Sean is next, and I have Mary showing, and Rachel. I'm going to have to close it at that, please, to be able to move on to Deputy Wallace.
Yeah, I think, Senator, that I wouldn't say that it's entirely depressing or that we're in the dark ages. Yeah, there are aspects of the system, and I'm using the word system as the chairman has said, there are aspects of the system, but it is a vast system covering the whole country and covering all ranges of people's lives. I think that's what makes the family system somewhat different to perhaps even the criminal system. because you get involved in every aspect of the person's life, not just the child-related issues, but also their financial issues, company law issues, pension issues, their housing issues. As someone said, a holistic approach is required. There are problems, but in my submission, the problem is mainly down to one of resources, because the system operates not quite on a shoestring, but close to it. Now, I appreciate we've had a bad recession 10 years ago, but I would have thought that at this stage we could be considering investing more money in it. We all seem to agree you need specialist judges with specialist training. It's the one thing that seems to be agreed. But I don't think you need to spend all your money on a new panoply necessarily of courts and judges and registrars. Yes, you do need the personnel, but you have an existing structure which works quite well. Like in terms of the district court, it has its rules. The circuit court has its rules. The reason we have a high court is that it will define the law. Life is dynamic. The family system is no different. You will not be able to write the rule book for all occasions. Yes, it's good to write the rule book, but you have to have cases going up to a high court or even beyond, so they can say, well, look, this is what happens in this area. If I give you a very short example, for example, the Oireachtas passed legislation in 2010 governing civil partnership and cohabitation. The problem with the cohabitation legislation, and I think if Nuala was allowed to speak, she'd agree with me, there's been no analysis by the higher courts as to what is to be done and how you apply the sections of that Act in, say, deciding what type of compensatory maintenance or property adjustment order should be made if the court finds there is cohabitation and a financial dependency. That's a problem for the Circuit Court. It's a problem for practitioners. So, while most cases might happen at a lower court level, the structure is actually, and it historically works, you do need the higher courts there to set the law. Otherwise, you will get all the district courts coming at it differently, all the circuit courts coming at it differently. Whereas you have that structure, and I would have thought, it's not so much that if it ain't broke, don't fix it, but you don't necessarily need to reinvent the wheel. I'm not saying it's a tweak that's required. You do need substantial resources, and you do need to write new rules, and you do need to train people. But it can be done with resources within the existing structure. In fairness to the personnel of the court service and the judges at all levels, most of them work very, very hard to provide some service. It's difficult with the burden that is placed on them. And that's particularly true of judges and civil servants in the district court. The burden placed on them is enormous. And with no disrespect to the Oireachtas keeps on giving them more functions. But if you're going to give more functions, you have to give more resources. And I'll finish on that. And just very briefly on the mediation, I think we all agree that you need to weed out bad mediators. At last we have a Mediation Act. As Dr O'Shea has pointed out, there is now movement towards the establishment of a mediation council, which will produce codes of conduct for mediators, and I think that will go some way towards resolving that issue.
Now, again, I have to respectfully request everyone to keep their contribution short, because I don't want members to be left out. Mary, Rachel, and then Carol will have us, and she's shown to me it's going to be very small. Mary.
Just to respond to Senator Black's, you asked the question, how do we how like it's so depressing, how do we get here? And I mean, we referenced the 1994 Law Reform Commission report, their recommendations. So if you come 25 years on, like there have been huge societal changes, and everybody in the room knows this. We have, I think, 12% of our population are immigrants now. I mean, we have a walk-in service. We have women coming into us who, they don't speak English and they're looking for assistance with forms and the whole lot. So you have that. You also have now, society has changed for the better in lots of respects, in that you have people are much freer and, they don't, marriage is kind of going out of fashion. People have, can have children by different partners. So there's all this, and so you have this at one level, and then at the other side, you have a family law system that is like it has changed very little. You have the legislation has improved, we acknowledge that. And then you have the other issues that you're not resourcing the system, you're not resourcing families again, you're not, you've public services that are just in disarray. And you have this is what you have then, the shambolic, total system.
All right, Mary, Rachel.
Very short. Very short. Thank you, Senator. Just in relation to what you put to Dr. O'Shea, just in relation to the kind of mediation and your own personal knowledge in the background, I think Sean got a bit of pushback earlier, but in fairness, I suppose Sean wouldn't deal with the day-to-day stuff of the district court, which I would, and I don't have the facts, and figures that Dr. O'Shea perhaps needs and wants. But all I can say is that in relation to the domestic violence application that I deal with on a daily basis, and I can only speak for myself, the threshold in relation to obtain one of those orders is fear, and if fear is there and an order follows, I would just say myself, of my own view, that those type of cases are just not appropriate for mediation, and I can only speak.
Thank you, Carol. Oh, sorry. Thank you, Rachel. And Carol, please.
Well, just very briefly, again, we have seen lists of over 120 cases on the one day, and in theory, the length of the court day is meant to be 6 hours long. You don't have to be a mathematician to work out that's 3 minutes a case. The crowding is unbelievable in some places. It's not universal. In Dublin, it certainly works an awful lot better. So it just can't be possible to devote adequate attention to all of those cases, even if an awful lot of them are adjournments and mention and all those little technical things that have to be done. I would also say that there is a need in the district court for resources to be put into case management so that cases can be planned, people know when they're coming up, they know the documents they have to have, they know the reports that have to be in. There's a handful of courts around the country where the judges do attempt to do that, but they are a minority. And that goes back to the first question you asked, why are we here? Because family law has been the poor relation of the whole legal system for far too long, because it doesn't involve crime, which has headlines in the newspapers, and it doesn't involve, by and large, money and commercial transactions. And they have been prioritised within our court system down through the decades, rather than the welfare of families. It is more than 20 years since the Court Service Special Committee itself, headed by Susan Denham, recommended a family court, which means, not a structure, a physical structure, but an organisational structure, which would allow for coherence and would allow for, as we keep saying, specialist judges, but not just specialist judges, would allow for case management, would mean that if a decision is made about the hearsay evidence from a child in one district court, or rather if it is made preferably by the High Court as to how it happens, then you're not going back in each and every time the issue comes up in Donegal or in Limerick or in Dublin, and there's a couple of days devoted to arguing about it all over again. So we do need to have that kind of coherence brought into the system, which has been sought over and over again. I understand that there's the heads of a bill lurking, in preparation, and I would hope that all of you as legislators, can I just appeal for you to push the Minister and the Department to bring forward what is already in process, I understand, in the Department of Justice, and to ensure that it is enacted as quickly as possible.
There's a lot of legislation lurking around this place. Thank you, Senator Black. Deputy Mick Wallace, please.
Thanks very much, and I promise I'll be brief. Because we're here too long, probably, if you're liking. Just a couple of specific questions first. Sean, you're on about the site on Hammond Lane. I think the OPW paid about $4 million for it back a long time ago, about 20 years ago. Do you know why it was stalled, and have you ever charged the government on it? I'll just throw in a few questions together, right? Otherwise, we'll never get out of here. You talked about the need for increased funding for the Legal Aid Board in order to make it fit for purpose. I think everyone obviously agrees with that, but I'm just wondering, has there any cost analysis ever been done on it? Have you any idea what exactly would be required money-wise, number-wise, in terms of making it fit for purpose? Carol, you were on about the in-camera stuff, and I know you've been doing loads on that area. I'm just wondering, you were pointing out that presently the potential fines is is scaring people off from even covering the stuff. I'm just wondering, have you any easy fixes as to how the system should work that would be bring more positive outcomes? And there's been a lot of talk about the fathers probably poor representation or poor outcomes sometimes, and is the in-camera situation kind of impeding that? Conor O'Mahony was jumping up and down about the chilling effect of it last week, about the in-camera system, and I'm just wondering, is there any easy fixes? There probably isn't, but I'm just wondering your thoughts on that.
Will we take those three first?
Right, okay.
All right. There are two to you, Sean, and then one to Carol. I'll take these first, and then we'll revert to the Deputy.
Yeah.
Please.
The short answer is I think that Hammond Lane, if we can call it that, has been stalled due to finance. While it was purchased 20 years ago, it came into by the OPW. It came into the ownership, I think, of the court service in or about 2015, 2016. And I should say that family lawyers were prevailed upon in the childcare area to move into the Bridewell courts as a temporary measure, much against their better inclination, because they were told, well, look, you'll be in Hammond Lane by 2021 or 2022 at the latest. That was the line that was sold. We didn't really believe it, but we bought into it. Now, it moved on, as I understand it. Planning has been obtained and building estimates have been obtained. I've heard headline figures, I don't know how accurate they are, of 80 million, but that is not enough, and it's back to the drawing board. We have made representations to the court service directly on the issue, but beyond that, no. I suppose we have tried to deal with it in a positive way, that hopefully this will happen, and we have not gone sort of shouting and roaring. I think that's where we have to go next in lobbying the relevant ministers. But it's a vacant site which is still there, and if it's only finance that's stopping it, well, I don't want to overstep my position, but with respect to surely the money could be found from somewhere to build what is a very, very important structure, which will be the facility for family law in the Dublin area for a long, long time to come. I'd say a century at least. But it definitely has stalled at the moment, and there is no progress. And it means that the other buildings which were starved of funding in the recession and in the anticipation of Hammond Lane are actually getting worse, and the overcrowding is getting worse. So we are at a crisis point in respect of Hammond Lane. In respect of the Civil Legal Aid Board, I don't have figures for you, Deputy. We haven't carried out a cost analysis. But it is clear that the solicitors and the administrative staff of the Legal Aid Board just cannot cope with the volume. And there is also, as I think someone else mentioned earlier on, that the income threshold to qualify is quite low, and that would certainly need to be looked at.
Thank you, Sean.
In relation, yes, to Conor O'Mahony's point, the in-camera rule, I think it exists rightly to protect the privacy of people who are dealing with extremely sensitive and difficult issues. However, I think it has been interpreted, and particularly by, I think, the Child and Family Agency, over strictly in terms of access to information, access to the kind of information that could be operated via specialist research institutions like universities and so on. The Act that was introduced in 2007 specifically allowed a whole number of nominated bodies to attend family law course and report on family law subject to the anonymity. That didn't, of course, extend outside courts, so that if any kind of work needed to be done of a research nature involving children and care, clearly specifically, that isn't covered by that bit of legislation. And I think there certainly is room for looking at how bona fide researchers, subject to a whole set of protocols and controls, and ensuring that there isn't any invasion of the privacy of the families and the children concerned could have better access to families and to children in order to inform us all as to what better practice and how practice might be improved.
Deputy.
There's Ruth, you were talking about the unmarried fathers having no rights, you're pointing out to do in Northern Ireland. I'm just wondering, I presume in other European countries, what's the state of affairs in relation to that? And you're saying that the father's guardianship rights to kick in when the father signs the birth register, and that people who are not married have been discriminated against. Does this automatically require legislation to fix, or is there a quicker way of doing it? Because, Carol was on about pushing ministers to go places. I'll tell you what now, if you think your job is frustrating, right, you come in here for a while. But things happen very slowly, and the Department of Justice are even one of the slower ones. So I'm just wondering, is there areas, is there work that can be done at the moment without legislation being necessary? But obviously we should be bringing in legislation where we require it. But I'm just wondering what improvements can be made in that area without legislation. Also, there's a couple of things there's a whole lot of weaknesses in the system that have been pointed out. The contributions have been very good and very informative, and obviously we're learning more about them, and we will be doing a report on whatever. But there's so many problems in so many areas that he's representing. I'm just wondering, what kind of advice can you be giving us as legislators as to how we parcel it all? It is so diverse and so just so many parts to it altogether. It's a bit mad. And then back to my other point, how much can we do now without legislation with regard to the judges? You're talking about improving the training, especially bringing in specialist judges, better training for them. Surely there's some judges there at the moment who are better at this job than others. Can they be identified to actually concentrate more on the area if you want specialist judges, rather than wait and wait and wait for this wonderful process to be put in place? So can we do things in that area now to actually shortcut the long wait for everything to be perfect? Yeah, okay, right.
Please, Ruth, would you like to start, please?
One, you ask, can something be done without legislation? There is one area that a start could be made. When Joan Burton was Minister for Social Welfare, she passed the Civil Registration Act, which provided for on every birth certificate that the father would be named on every birth certificate. That was passed but has not been commenced. And I understand the General Registry Office has argued that it doesn't have the resources to do it. But we are the last country in Western Europe that there isn't a requirement to have the father's name on the birth certificate of the birth of a child. So there, in a very concrete way, I think a step could be made towards recognising the rights of all fathers in relation to their child. We would argue that you need to go a step further then, but that would have to be done by legislation, which is that a father who is registered as the father of the child then is also the automatic guardian of that child, unless there are circumstances which would suggest that he's unfit to be such a guardian. So there's steps can be taken without legislation, but at the end of the day, some new legislation is required, and this is the place where such initiatives have to be taken. And I know all the backlog and the difficulties, but it seems to me that this is an area, and there are other legal steps that need to be taken to improve the functioning of our court service, family court service.
Okay, Sean and then Rushing, please.
Deputy, I think, sorry, I appreciate that things can move slowly, but sometimes for good reason, sometimes not. I think there's a lot that could be done with the family law system which doesn't require legislation, and to a large extent that's the undercurrent of the Bar Council submission. There is a requirement for, I suppose, government to decide to spend money on it. And unfortunately, in the world we live in, that is that's always tight, but that's what needs to happen. Without boring you, I think Hammond Lane needs to be built. It needs to be built now, not in 5 years or 10 years' time. Because it's not just courts, it's family-friendly spaces, it's spaces for mediation, it's spaces for the Legal Aid Board, it's spaces for social workers, it's play areas, it's cafes. You know, it's to have a proper functioning environment, and that needs to be built. In respect of judges, I think certainly in Dublin and perhaps in Cork also, the presidents of the various courts do more or less identify and judges self-select. And so you tend to get the judges who want to practice, who want to be judges in those areas doing it. But, and I'm not saying I'd be any better than them, but there is a need for training for those people. And it's not that they are bad in themselves, most of them are very good at what they do, but the resources need to be applied for specialist training. And those judges need to be left in that place for probably 2 years, whether it's the 80-20 rule that Dr. O'Shea mentioned to us, or 100%, so that you get the consistency. Because consistency, in my experience of litigation, is the key. If the practitioners know where the judges are going, you can advise your client accordingly. And unless the judge is not applying the law such that you have to appeal, you get a much more streamlined approach, and you get less time delays and less trials running to see what's this particular judge going to do with this topic. So that can be done without actually money, but you do need training, and training takes time and money. But Hammond Lane must be done. Outside of that, immediately, it's difficult to see, because I don't want to be Dublin-centric or Cork-centric, but once you leave Dublin and Cork, it's a much bigger issue, which does probably require a far greater analysis of how could you use existing court buildings more efficiently for your courts, for your mediation services, or do you have to spend the time and money building new buildings? What I'm saying is I hope you wouldn't have to do that, that you could spend the money on existing facilities and maximise the usage of those facilities and the personnel within them. And I think that could be done. In Dublin and Cork, I think this can all be done very fast if Hammond Lane is built. I appreciate that's a time lag. Outside of Dublin and Cork, it's probably slower, but it doesn't have to take forever. It might take a year, but I think it could be got up and running. And the legislative changes, if necessary, can follow.
Thank you, Sean. Rushing, and then Maria, I understand.
Yeah, I think the reality here is that you guys are politicians, right? So you know that public pressure brings about change. When the public pressure gets to enough of a point, that will motivate. You guys are not mainstream, as in, you know, you can do, as you said, Deputy Wallace, you could put as much effort, you could put a huge amount of effort in, but if you can't convince the larger parties to come with you, then you know, your work is much more difficult. And I think what's happened is the legislation has actually progressed faster than our systems have moved on. And I think, like Alan Shatter, the former minister, I mean, we need to give credit to the extraordinary work that he did, and he brought in incredible changes. When I was in Canada, I'm in Canada again in May, presenting on Ireland, by the way. I'm presenting on domestic violence in the district courts here in Canada at the end of May. And the last time I was there last year, they said that they couldn't believe the changes that had happened in Ireland, the legislative changes, same-sex divorce. You know, like, we have jumped and jumped and jumped, and so our politicians are actually doing a good job. Does anybody normally say that? But that is the truth. You know, it's a good job is being done here in terms of the family law legislative pieces that are needed. What is happening is the system, the core system, those big systems take time to change. And I think the sea change that we have to see is the legal profession. And I'm not criticising the legal profession, they have a role here, they have a key role here, but it's a very old institution. And we're very used to the idea, we as the public are very used to the idea, when we get into trouble, where did I go first when my marriage ended? To a solicitor. Why did I go to a solicitor? Because I automatically thought that's where I go. Why did I stay with the solicitor? Because I thought I felt protected. Why did I feel protected? When I look back at it now, it's why it brought me here. But I'm just saying, what happens is that we, society, and let's stop pointing the fingers at judges or solicitors or barristers, let's point the finger at ourselves fair and square, and we say, if we as a society don't start having that conversation about what is best for our children, what's best for us, where do we go, and that early intervention piece, if we can't figure it out, I think what we all should do here, and the people who gave other testimony, we should try and set out a very short checklist of what we think politicians could do right now as part of this piece, and then do a separate checklist of what, like for instance, with another hat I'm on the board of the Irish Mediators Institute, or the Mediators Institute of Ireland, sorry, and I convinced them to put up half the money to co-fund with the Irish Research Council research into child inclusive mediation. And I got both of them to agree to it, and they came up with the money, and that's going to start starting this week. And the researcher is Madeleine Tracy. She's from WIT. She was the successful candidate. Deputy Black earlier on said, why are we here? We're here because we're not doing enough research. I would support what Carol is saying. We need more and more data coming out of the courts to inform what we're doing. I apologise. And we need to use that data, but also look at what's going on elsewhere. As Sean said, we don't need to reinvent the wheel. So maybe we need to identify more closely what politicians can do here.
Thank you, Russian. Well, this politician has only one last remaining task. Maria and Carol, you're going to have to decide which of you, and it is a single sentence, because the advance guard of the next committee are here already, and I have a job to wrap things up. Maria, you have the final word.
I think one way that the committee could look at their final report is what do we need, what can only be fixed by a specialist family court. And then the other issues are amendments to legislation, they're budgetary issues, they're infrastructural issues. But some things we actually need a specialist family court to fix. So that, to divide it up in that way is just a suggestion.
Sorry. Well, no, I apologise to Deputy Chambers. I hadn't noted his indication. I thank Maria. Mick, 20 seconds, and Jack a single minute.
Are also the ones who are not resourcing all these different areas, which Mary has been pointing out as well, and your own legal part as well.
I have no party politics
Mary,
at all.
you mentioned about, and I missed it, about a form that's only really been applied in Dublin and Cork. That's kind of given guidelines in a particular area, and as we're talking about parental guidelines. So, I might be naive thinking that the judges could be given guidelines as to how they should become more child-focused, given that these are all kind of in agreement that there isn't enough emphasis on the child focus in how we're doing things in this area. So, would it make sense?
I can't open that up to everybody. Ask one to respond.
No,
no, you can't do it.
Well, that's
sorry,
them. We haven't heard them.
You'll have to engage privately to get the answer afterwards.
That's Damien then. The answer.
Damien, a single answer.
Yes, I think, but more importantly, I think, an information campaign wouldn't require legislation vis-à-vis what happened in Australia. It could solve a lot of issues in terms of getting the correct information and the dialogue happening in the wider public. But yes, I think there's some practical things around protocols.
Thank you, Jack. You have the floor. Thank you, Damien.
I said I was in and out myself.
I'm really sorry.
I appreciate that there's another committee about to start, but thanks everyone. Their submissions are very comprehensive, and I just had two brief questions, and it may be an answer, but just Dr. Coulter, I spoke with Dr. Manny when he was here a couple of weeks ago, and the whole academic piece. I remember studying family law myself at Trinity, and the whole issue, as you mentioned, around the in-camera. You mentioned a dedicated reporting body. And I support that. Like, what structure can you relate to that, say, elsewhere? Like, who runs it? Who, just to get more about what that would entail and how we could make it workable. Like, would it be through the court system? Is it through the department? Is it separate through legislation? I'd just be interested to know the detail around that dedicated reporting body, because I think we need to move on that, and it's holding a lot of this back. And then, a separate point, just in terms of the Bar Council, just obviously you mentioned the High Court and how it deals with complexity. I know one person who knows more about family law than I feel, has said to me that Ireland has an excessive use of High Court time around family law at times, or is that just, can we comment on that, or is there a way of displacing a lot of the cases back more to court rules, and just briefly, and thanks, Chair, for
Thank you, Deputy Chambers. Carol first, Sean second, and I mean, this has to be very, very tight.
Yeah, well, at some point I would be very happy to speak either to the committee or to any individual member of the committee in much more detail about this, because it can't really be answered in a couple of sentences. But I think the experience of other countries has been that where the media are permitted to attend family law proceedings, which they are in a large number of countries, there remains very little, no comprehensive coverage and very little coverage of family law proceedings in any kind of balanced way, because what the media tend to focus on are high-profile cases where, where that's permitted, where they can identify the families, if they're particularly high-profile families or celebrities or whatever, the kind of bread and butter of family law proceedings, which is what most people experience, never ever get reported by the media in general. And where judgments are published, again, is only a small selection of judgments. It doesn't necessarily cover the vast majority of things that actually happen, which goes to the issue of information, which was raised by Thor. It means that information is not then readily available. So that is why I'm happy that there's some now international interest. And actually the model developed by accident, by a series of accidents, which a paper on this is on our website describing how our project came into being. And it is able to both publish reports so that cases are then described for the general public on a website accessible to everybody, but also collect data which can be the raw material for research and to look at trends and to look at developments and hopefully then lead to recommendations. So as to what further mechanism might be used to ensure that that can continue after the end of our project, because we're going to finish up in 2 years' time and we only do the child protection, I would hope it could be an integral part of legislation providing for a family court, so that the transparency could be assured within any new family court, transparency and accountability as an integral part of any new kind of family court structure. And apart from anything else, the European Convention on Human Rights and the jurisprudence from that does require there be accountability, particularly where the state is involved in family proceedings, so that the state is not allowed to take action in relation to families without people being aware of what is happening. So, as I said, I'd be very happy to go into it in a lot more detail on either another occasion or with individual members of the committee.
Thank you, Carol. And Sean, this has to be
very briefly. Yeah, Deputy, it's a very pertinent question. I don't think the High Court is used excessively. If the statistics in our submission, which are taken from the Court Service report of 2017, would indicate that approximately 100-odd cases, excluding child abduction, which is a separate category, come before the High Court every year. We have, at the moment in Dublin, up to 7 dedicated district court judges in Dublin doing exclusively family law every day, 3 circuit court judges exclusively family law. So that's up to 10 judges a day in Dublin in the lower courts on family law alone. Cork would have a higher emphasis on that also. And then around the rest of the country, you have your district and circuit courts applying their time to it whenever they can, whenever their lists are structured accordingly. Yes, you do have circuit judges on occasion after an appeal hearing circuit appeals, but in terms of time and caseload, no. Pardon?
Are people trying to circumvent the lower courts through interpol? Not at all.
Not really. There was a time when I was a bit younger when people would bring custody applications in the High Court. Or, that doesn't happen anymore. They either form part of your judicial separation or divorce in the Circuit Court, or they brought as standalone applications into the District Court. I think most of the cases in the High Court, with probably 1 or 2 honourable exceptions, are merited to be there, having regard to the issues involved, the complexity of the financial matters. And as I said earlier, Deputy, I think it's very important that you have a High Court hearing appropriate cases to set the legal precedent.
That's it, and thank you so much. I'm going to, on behalf of the committee, thank from the Childcare Reporting Project, Dr. Carol Coulter and Miss Maria Corbett. Thank you both very much indeed. From the Bar Council, Mr. Sean O'Hulican, Dr. Sarah Fennell, who had to leave us a little earlier, and Miss Rachel Baldwin. Thank you so much. And from the Art Mediation, Dr. Rushing O'Shea, Director, thank you very much, Rushing. And from TROR, Dr. Ruth Barrington, the Chairperson, Damien Pilo, the CEO, and Mary Roach, the Policy Officer, and to wish each and every one of you the very best, and again to thank you for your contribution. The Joint Committee is adjourned until 9 a.m. on next Wednesday, the 13th of March 2019, when we will go into the third of our hearings on family law reform. Thank you very much indeed.